call to order the Zoning Board of Appeals meeting for Wednesday, October 25th, 2023. To all persons interested in or affected by the action of the Zoning Board of Appeals, you are hereby notified pursuant to Section 11 of Chapter 48 of the General Laws of the Commonwealth of Massachusetts and all amendments thereto that a public hearing on the following appeals will be held again Wednesday, October 25th, 2023. The Zoning Board of Appeals public hearing will be held by remote participation methods. Public access to this meeting shall be provided in the following manner. The meeting is televised live via Xfinity Channel 8 or High Definition Channel 1072. It may also be accessed via the Government Access Channel live stream or the Town of Barnstable's website, http://streaming85.townofbarnstable.us/cablecast public site/watch/1 Real-time access to the Zoning Board of Appeals meeting is available by utilizing the Zoom link or telephone number and meeting ID provided. Public comment can be addressed to the Zoning Board of Appeals by utilizing the Zoom link or telephone number and meeting ID. The Zoom link is https://townofbarnstable-us.zoom.us/J89407793072 or by calling 888-475-4499 and entering the meeting ID 894-0779-3072. Applicants or representatives and individuals required or entitled to appear before the Zoning Board of Appeals may appear remotely and may participate through accessing the link or telephone number provided. Documentary exhibits and or visual presentations should be submitted in advance of the meeting to anna.brigham@town.barnstable.ma.us so that they may be displayed for remote public access viewing. Copies of the applications are available for review by calling 508-862-4682 or emailing anna.brigham@town.barnstable.ma.us. All right, we'll call the meeting to order with an introduction of board members. Let's see, Herb Bodenseek.
I am present.
Paul Pinard is not present. Mark Hansen.
Present.
Aaron Webb.
Present.
Denise Johnson is not present. Larry Hurwitz.
Present.
Manny Alves.
Present.
And I am Jacob Dewey, Chair. Notice recording this meeting is the meeting of the Zoning Board of Appeals is being recorded and broadcast on the Town of Barnstable's Government Access Channel in accordance with MGL Chapter 38, Section 20. I must inquire whether anyone is recording this meeting. If so, please make their presence known. Seeing none, I'll note for minutes meetings, no one's recording. Minutes, we have no minutes to approve today, so it's going to take us to our first order of old business. Appeal number 2023-020, Jessica E. and Emily C. Davis have petitioned for a variance pursuant to Section 240-14E, Residential District Bulk Regulations, minimum front and side yard setbacks. Petitioners seek to reduce the 15-foot side yard setback requirement to 13.2 feet and to reduce the 30-foot front yard setback to 26.6 feet to construct an attached garage with storage area. The subject property is located at 190 Buckthorn Road, Marston's Mills, Massachusetts, as shown in Assessor's Map 047 as parcel 034. It's located in the Residence F RF zoning district and the Resource Protection Overlay District RPOD. This was continued from September 13th, 2023. Members were not assigned. The members sitting on this will be Herb Bodenseek, Mark Hansen. Aaron, do you want to sit on this or do you want to sit out?
I'm happy to sit on it, sure.
Okay. So Aaron and Larry. All right, then Aaron would be 5 and myself. Attorney Kenny, I believe this is you.
Yes, sir. Good evening, Mr. Chairman, members of the Zoning Board of Appeals. For the record, my name is John Kenny, an attorney with a law office in Centerville. Come before you tonight representing Jessica and Emily Davis. Jessica and Emily are here with me, or here via Zoom, as well as Patrick Nickerson, an attorney in my office. As you just read in, we're asking for a variance to allow for the construction of a 24 by 30 garage at the property at 190 Blackthorn Road in Marston's Mills. Pursuant to Chapter 48, Section 10, and Chapter 240, Section 125, B1C of the zoning ordinance, you were authorized to grant a variance, provided we establish that owing to circumstances related to soil conditions, shape, or topography of such land or structures, and especially affecting such land or structures, but not affecting generally the zoning district in which it is located, a literal enforcement of the provisions of the zoning ordinance would involve substantial hardship, financial or otherwise, to the petitioner, and desirable relief may be granted without substantial detriment to the public good, without nullifying or substantially derogating from the intent or the purpose of the zoning ordinance. The unique topographical features of this property are a combination. The property fronts on 3 roads. It has frontage on Jasper Road, Blackthorn Road, and Clover Road, which are unique circumstances in the Residence F district. And in addition, the placement of the original home in this lot was placed at an odd angle. Not quite sure why. Could never figure it out. My clients did not build the house; they bought it after it had been built and owned by somebody else. So they were kind of a second owner. But it's got an address of Blackthorn Road. It was built to be accessed from Jasper Road, and it was kind of built at an odd angle. It doesn't face the corner of Jasper Road and Blackthorn Road. It doesn't face either road. It's just built at a very odd angle over to the right-hand side of the lot as you face the lot from Jasper Road. As I stated, even though it's got a Blackthorn Road address, it was designed to be entered from Jasper Road. A literal enforcement of the provision of the zoning ordinance would involve substantial hardship. Basically, if you were to literally enforce the zoning ordinance, it would prevent them from building the attached garage on this property. Given the number and location of the trees in the lot, and if you look at the Exhibit D, Exhibit C, photograph that we submitted, you can see the trees on the lot and how the home is situated kind of at an odd angle on Jasper Road. But it would be very difficult and costly to build this garage in any place other than where it's proposed. All the trees that are along Blackthorn Road and on the corner of Jasper Road afford privacy both for my client's property as well as the neighbors across the street. It would be very expensive to have to take those down, pull out the driveway that's on Jasper Road, put in a new driveway. It would also require them to reconfigure the current floor plans of their home because their bedrooms are on that side of the house. And also the utility lines come in off of Blackthorn Road, the gas and electric would require them to be relocated. And if you look at the site plan, it just doesn't fit with the pool deck and the pool behind them. So there's really no other place to fit this. And if you look at Exhibit D, the photographs, you can see that the area where the garage is proposed to be placed is already clear of trees. It's kind of set up for the garage, so it's not going to require cutting of trees that would impact anybody else. So it suggests to you that the relief sought by this request for a variance can be granted without substantial detriment to the public good or without nullifying or substantially derogating from the intent of the purpose of the zoning ordinance. Well, what we're asking for is a variance here to go from the 15-foot side yard setback down to 13.2 feet for just the back right corner of the garage. And then on the front yard setback off of Jasper Road, we're asking them to go from 30 feet down to 26.6 feet. And that's just the front right corner of the garage. So there are significant buffers still provided. It wouldn't require the removal of trees that are protecting anybody from my client's property. And if you look at the abutting property next door at 19 Jasper, that house is, as you face Jasper, is towards the right center of their lot. So there's a significant tree buffer between where the proposed garage would go and where the most impacted neighbor is. My clients want to continue to use Jasper Road as the main access point for their property because it is a much less traveled road than Blackthorn Road. Blackthorn Road kind of is a main thoroughfare for people going in and out of the neighborhood. Jasper Road is a much less heavily traveled road. There is a driveway off of Blackthorn Road onto the property. My clients have informed me that was built by the prior owner for storage of an RV. They don't use it except their dad, who lives down around the corner, comes on occasion and takes care of their lawn for them, and he'll park there when he's gonna mow the lawn for his daughters. But other than that, they don't use that area. There'll be no increase in the intensity of the use. There's still a significant front yard buffer of setback of 26.6 feet to that one corner where we need the variance. It's 13.2 feet to the other corner in the back from the side yard setback. So there's no impact on anybody. They're going to use identical materials and color schemes to match their house, so it'll fit right in with the neighborhood. And my clients went around and canvassed the neighbors, and everybody across the street on Jasper Road, everybody across the street on Blackthorn Road have sent in letters of support. And then in addition to that, today, this afternoon, and I did email this into the town, but it didn't get into the record, but the people at 19 Jasper Road with a 13.2 foot setback have sent in an email. Their names are Kathy and Ron Driscoll, and it says, this was received this afternoon at 4:19 p.m. Hi, Jessica and Emily. It was good for Ron to meet and talk to you yesterday, and thank you for sending the information, update, and plan. You have our support for the variances needed for the building of the garage, which involves a 13.2 foot setback rather than the 15 foot side setback from our property line that is usually required by the town. Good luck with your meetings and getting the garage built. Kathy and Ron Driscoll, 19 Jasper Road, Marston's Mills, Massachusetts. So they have support of all neighbors that would have any view of this. As I stated, minimal to no impact on anybody, and it's really a couple of minor variance requests from 15 feet down to 13.2 feet for one corner and 30 feet down to 26.6 feet for another corner. The vast majority of the garage meets the setback requirements. And I'll be happy to answer any questions the board may have.
Thank you, Attorney Kenny. Does anyone from the board have questions for the applicant?
I have a very quick question. So I'm just looking at the plans, and so this has a storage space up above, correct? And to access that is a staircase at the rear of the garage, correct? So if you didn't, just out of curiosity, if you didn't have the storage above and you didn't have that staircase, would you require a variance?
Yes, we still would.
You would, okay. Okay. Because that's obviously a minimum width for a garage of that size, and that was just my question. Okay, thank you.
Anyone else? All right. So let's open up public comment on this item. We did receive, I don't think, Anna, we didn't receive, is that letter that Attorney Kenny just read in already in our folder? No, I don't think so, right?
No, I don't think so. It came in too late.
I'm sorry, Anna, I didn't mean to interrupt. It came, I didn't forward it to the board until 4:40. Well, I received it from Jessica at 4:42 today, so it was after the business closed for the town, but I did send it into an email form, and then I figured I'd read it into the record tonight. There are 6 other letters of support. This is the 7th letter.
Okay. I'll briefly just go through the letters that were received in our folder. So there's a letter in support from Corey Haskell at 191 Blackthorn Road, Marston's Mills. There's a letter from Timothy and Susan Miller at 154 Blackthorn Road, Marston's Mills, in support of the project. There's a letter from Gregory and Marianne Williams at 26 Jasper Road in Marston's Mills in support of the project. There's a letter from Jonathan Corsino at 167 Blackthorn Road, Marston's Mills, in support of the project. And a letter from John and Karen Trapp at 168 Blackthorn Road, Marston's Mills, in support of the project. And a letter from Susan Cox and Stephen Callahan at 179 Blackthorn Road, also in support of the project, as well as there was a map here that showed where all those people live that was submitted. And then in addition, the letter that Attorney Kenny read into the record. Is there anyone here that wants to speak to this item? Just unmute yourself and make yourself known. Okay. Seeing none. I'll make a motion to close public comment.
Second.
Roll call vote to close public comment. Aaron Webb,
I'm in favor.
Herb Bodenseek,
In favor.
Mark Hansen,
In favor.
Manny Alves,
In favor.
Larry Hurwitz,
In favor.
and I'm also in favor. So public comments closed on item 2023-020. Brings it back to the board for deliberation. Does anyone have any thoughts or questions or
I'll make findings if nobody has questions.
they don't have any thoughts or questions?
I second Mark.
Okay. So Mark, yeah, go ahead. Just remember it's a variance, so make sure you're leaning on what you're leaning on.
Yep, not a problem. Regard variance number 2023-020 Davis, section 240-14E, bulk regulations in the RF district. Jessica E. and Emily C. Davis have petitioned for a variance pursuant to section 240-14E, residential district bulk regulations, minimum front and side yard setbacks. Petitioners seek to reduce the 15-foot side yard setback requirement to 13.2 feet and to reduce the 30-foot front yard setback to 26.6 feet to construct an attached 24 by 30-foot two-car garage with storage area. Subject property is located at 190 Blackthorn Road, Marston's Mills, Massachusetts. Statutory requirement of MGL Chapter 40A, Section 10 for granting a variance is a three-pronged test. Board is required to find that each of the following three requirements has been met in order to consider granting the variance. Number one, owing to circumstances related to soil conditions, shape, or topography of such land or structures, and especially affecting such land or structures, but not affecting generally the zoning district in which it is located. I find that the placement of the lot being a corner lot flanked and abutted by three separate roads, and the angled placement of the dwelling itself poses a unique circumstance with regard to the land and both structure. Number two, a literal enforcement of the provisions of the zoning ordinance would involve substantial hardship, financial or otherwise, to the petitioner. I find that there would be both a financial hardship through the necessity of major reconstruction of the home in its existing condition. And also, without this provision, this variance, they would literally have an inability to construct the dwelling as proposed because there is no other location. So we have a financial hardship, and it's a choice between either that or the inability to construct. Number three, desirable relief may be granted without substantial detriment to the public good and without nullifying or substantially derogating from the intent or purpose of the zoning ordinance. I find that we can reference the 6 letters, technically 7 letters of support. The size and scale of the property fit within the neighborhood, and the addition is scaled in reasonable size to the existing dwelling. Those are my findings. Sorry about the stammer.
All right. Thank you for the findings. Do we have a second?
I'll second that.
All right, Herb. And a roll call vote on the findings. Herb Bodenseek,
In favor.
Mark Hansen,
I'm in favor.
Aaron Webb,
I'm in favor.
Larry Hurwitz,
In favor.
and I am also in favor. Mark, do you have some conditions?
I do, referencing staff report dated August 24th, 2023. I have suggestion conditions 1 through 4, and have those been reviewed, Attorney Kenny, and are those acceptable to you and your client?
Yes, they are. Thank you.
All right, so I'd like to put forth those conditions.
All right, so Mark moves to grant the variance 2023-020 with conditions. Roll call vote. Herb Bodenseek,
So sorry, Zoom. In favor.
Mark Hansen,
I'm in favor.
Aaron Webb,
In favor.
Larry Hurwitz,
In favor.
And I am also in favor. So Attorney Kenny, you have your variance.
Well, very.
Yeah, I'm in favor as well.
Oh, sorry. Manny. Oh,
Yeah, there were 6 members assigned, but that's
yes. All right, moving along.
Good luck.
Appeal number
Good night.
20 Thank you, Attorney Kenny. Appeal number 2023-019, Kevin Y. and Corey L. Vilsant have applied for a special permit in accordance with section 240-47 to accessory dwelling units ADUs. The applicants seek to remove and replace an existing accessory structure with a new accessory dwelling unit ADU. The applicants also seek to modify special permit number 2020-038 to allow further build out of the property for the accessory dwelling unit and additions to the principal dwelling. The subject property is located at 358 Flint Street, Marston's Mills, Mass. As shown on assessors map 101 as parcel 121. It's located in the Residence FRF zoning district. We have members assigned of myself, Aaron Webb, Herb Bodensig, Paul Pinard, and Denise Johnson. This was continued from August 23rd, 2023. And we have a request from the applicant to continue this to December 6th, I want to say 8th. What is it? 6th. Anna, do we have like sufficient space on that meeting? That's going to be Zoom, correct?
Correct.
Okay. And we're okay agenda-wise?
Excuse me?
We're okay agenda-wise to fit it on?
I believe we can squeeze this in.
Okay. All right. So I will make a motion to continue this to December 6th, 2023. Do we have a time? How many are there? 7:03.
Just 7 p.m.
All right, to 7 p.m. I need a second.
Second.
All right, roll call vote. Herb Bodensig,
in favor.
Mark Hansen,
In favor.
Aaron Webb,
In favor.
Larry Hurwitz,
In favor.
Manny Alves.
In favor.
All right, so that item is continued. Moving along, let's see. Next item is appeal number 2023-029. EM Crosby Boatworks Inc. has applied for a special permit pursuant to section 240-94A and section 240-94B, change or expansion of a pre-existing non-conforming use. The applicant seeks to change the use from a landscaping business to a boat storage business. The applicant proposed to store up to 75 boats on the property. The applicant also seeks to construct an approximately 30-foot by 80-foot structure covered with a clear membrane to be utilized for the storage of wooden boats. The subject property is located at 140 Osterville, West Barnstable Road, Osterville, Massachusetts, as shown on Assessor's Map 120 as parcel 051-002. It's located in the Residence C RC zoning district and the Wellhead Protection WP overlay district. This was continued from October 11, 2023. There were members assigned, which was Herb Bodensig, Mark Hansen, Aaron Webb, and Denise Johnson. And seeing no testimony was taken, can we assign someone else or? All right. Or does someone have to mull it in? Or do we have to hear it with 4?
Was Larry here? Was somebody
I
here?
think Manny was also assigned.
Manny was here too.
Manny was assigned?
Yes.
Yes? Okay. So we have Herb, Mark, Aaron, and Manny present.
Mm-hmm.
So, Anna, do you want me to run this and not vote on it or hand it to Herb?
Are you recusing?
I don't need to recuse myself. I will disclose that I own a boat business, but I don't think that I don't have any business dealings with the applicant.
Okay.
But
I
I'm not assigned to vote.
I believe Denise was also assigned.
Yeah, she was,
Yes, but she's not here.
but she's not here. I said Herb was what I see from the record is Herb, Paul, Aaron, Denise, and Manny.
Not Paul. I think Paul
Oh,
recused.
sorry. I mean, Paul recused himself. Herb, Mark, Aaron, Denise, and Manny.
Is that 5?
1, 2, 3, 4, 5. That was 5 assigned, and Denise was the 5th, but she's not present tonight.
But we didn't hear anything.
We didn't hear anything. I have no objection to you mulling in, Mr. Chairman, or if you want to just restart the whole thing, I don't know, whatever procedural method, I'd obviously prefer 5. And whatever the board deems fit, we're prepared to do.
And what do you think procedurally makes, this is beyond my.
Well, just from a procedural standpoint, mulling is simple because there was no testimony provided. So there is no, I don't think that there's any prejudice that would affect the project, since literally I stood up and asked for an extension until today's date. And I explained that we had met with the neighborhood and that we were planning on meeting with the neighborhood. That was the extent of my representations before the board.
Yes, that's true.
Look, you can see the reflection of the TV
Yeah.
or his computer.
So, and are you comfortable with?
I am.
Okay. So I'll assign myself, and if the applicant has any objection, I will disclose that I own a small Cape Cod boat business, primarily in the motorboat business. I think Mr. Crosby's business is much different than mine, and not located anywhere near mine. This property is not located anywhere near mine or in the same town.
Absolutely no objection.
All right. So, Attorney Lawler, it's up over to you. I think I assigned members. Yes, we're good.
Thank you. And good evening. David Lawler for the record. Beside me is Ned Crosby, the owner, EM Crosby Boatworks, Inc. Just briefly, the Crosby family has been in the wooden boat building business for a couple of 100 years, actually way back when invented the catboat. And it's a long and storied tradition. And one of the problems we have on Cape Cod is it's become very difficult to find places to store boats. We're a maritime community, an ocean-based, water-based community. One reason or another, everybody comes here for the ocean, whether it's the breezes, the beaches, or the boating. And we have a particular piece of property located at 140 Barnstable, West Barnstable Road. It's a pork chop lot. So virtually none of the road is directly visible from, was certainly well set back off of Barnstable, West Barnstable Road. And the lot is subject to a land court case in which there was actually in 2000, a land court determined that the lot, in fact, is pre-existing non-conforming. There was a Barnstable zoning case that was eventually appealed to the land court. The land court ruled in favor of the applicant owner, Mr. Veer, at the time, finding that his very large landscaping business was pre-existing non-conforming. And what we're trying to do here is change from one use, one non-conforming use to another under 240 94A B. And what in particular, the standard, being it's not more detrimental. There's already a determination that the lot is pre-existing non-conforming. And what Mr. Crosby is intending to do with his business will be substantially less detrimental with respect to traffic, with respect to septic and water flow, with respect to noise, with respect to smell. The prior applicant had a giant mulch and manure or mound. It was probably 15, 20 feet high and covered almost the entire back lot. And on occasion, they would move it around or recirculate it. And for lack of a better term, the neighborhood became a little ripe. And so that will be going away. And the activity usage in every respect will be less than what the pre-existing non-conforming use in play is, and it's and that use is was ongoing up until I think less than a year ago or so. So clearly falls within the 3-year rule. So what happened is we were before this board last meeting, and the neighbors. If you look at the lot, Anna, could you pull up the site plan?
Sure.
Thank you.
Hold on one second.
And I do actually, I'm going to take a step back before I address this. So I had conversations and communications. This has been through informal site plan with a handwritten plan that was done by me. It probably looked like a first grader, and then probably giving myself some credit. And the reason being is that I think we all know that engineers and surveyors are so backed up, and there were some time constraints with this application because, you know, if we're successful in obtaining the approval of this board, we obviously want to store boats, and next week's November, and they're coming out of the water if they're not out of the water. And that's why there was some of the urgency. And my understanding is, in speaking with the building commissioner, that if we would bring this to formal site plan on November 2nd, and any order that would be issued by this board, if we're fortunate enough to do so, one of the orders of condition would have to be that it would be subject to site plan approval on the 2nd. I will represent to the board as an officer of the court that the site plan really only issue was that we obtained zoning board approval. The only other comments were made by the fire department to make sure we kept the road open, which we obviously will. So in looking at, and now stepping back to where I was, so when we were at the meeting 2 weeks ago, a lot of the neighborhood, if you look where on the boundary line on the right corner, that's in Hickory Hills. And there's 3 residents that directly abut that sideline of the property. And those residents were at the meeting and a few more from the neighborhood. I think we had a very productive meeting. We went into the conference room there, the council conference room, for well over an hour and discussed their concerns. I mean, obviously they're their homes, and they have some very legitimate concerns as to what was going to be there. Not only did we meet them there, Mr. Crosby and myself, we met the neighborhood at the property some 4 or 5 or 6 days later, and had conversations with them about what we were going to want to do. And I know from looking at the list of people, there are some abutters still here, and I want to be very careful with my words, but I think we made some concessions with respect to this parcel. A lot of them really weren't even concessions, but the property is wooded with pine trees on that upper right-hand corner, right where the arrow is right now. I'm sorry, right almost where the property work line is on it, where you were, on that, right by Hinckley. I mean, right around there. So there's a myriad of trees, a lot of small white pines and some big white pines. And where we showed the work line, that's a 20-foot buffer. Now, under zoning, back and sidelines are a 10-foot buffer. And actually, we voluntarily said we don't want to put anything within the 20-foot buffer to make sure that there are, plenty of room between the boat storage and the neighborhood. To the right is a nursery, and to the left is a contractor's yard. And in front of the property are properties owned by the party that owns this particular lot. So the real issues or concerns of the neighborhood really come from that back portion of the lot where you see the 20-foot work line. In addition to past the 20-foot work line, there is an intent to cut some trees, but not all of them. We'll probably cut most of the smaller trees. There are some very large trees there that we intend to keep and just store boats around the area. We do not intend to change any of the lots at all. There is no change whatsoever. In a second, I'll talk about what I would refer to as a temporary structure, though it'll be up for a while, the membrane structure that was read in the application. But the roadway or the driveway is paved, and there's a garage with a living unit in it that's at the property. The use of the property will be for boat storage only. We agreed with the neighbors that there'll be no boat work done. There'll be no mechanical work, no woodworking. It's strictly for boat storage. How Ned operates his business, he has a small little area on Bridge Street in Osterville where there's a ramp there and there's another structure there. They pull the boats out, they clean them, they do whatever work is necessary on them. There's a smaller area to store boats there. They prep them for the winter. They wrap them. Or as when in the case of the Miano seniors, they cover them. They don't put the plastic wrap on them. And they bring them over, hopefully over to this lot to sit for the winter. They will come and arrive, for the most part in mid to late September through October and into November. And they will leave generally in May and June. When a boat's dropped off, it's dropped off, and then it's not touched again until the spring. So the actual usage of this lot, once the fall pickup occurs, is very minimal. When we had the meeting at the property, Ned brought the truck I think it's a Ford or a Chevy 250 gasoline. It's not diesel, so it's not noisy. And he brought his largest trailer, the only one that has kind of makes a little bit of noise when it's very small. It just has a small compressor on it. And we displayed that to the neighbors as to the extent of what the noise would be of, I guess when they drop the boats off and there'll be people talking and whatnot, but as compared to the prior use, it's extremely minimal. There were some neighbors expressed concerns about lighting. We agreed that we do not intend to floodlight the boat area. We had no intention to do so anyway, so that was pretty easy. With respect to, I don't want to miss anything, some of the neighbors had concerns that customers would come and work and utilize their own boats. This is not a yard for customers to do work on their own boats. My clients in the repair business and mainly the wooden boat business. The reason for the application says 80 by 30. Actually, we've reduced that prior to when that wasn't a concession. I mean, certainly I don't want to portray it to be one. But Ned decided the use for the membrane structure would be 60 by 30. And what happens there, he's able to store 9 Wiano seniors. Six, I'm sorry, 3 by each way, 6 Wiano seniors. Wooden boats don't like to be on concrete, and some wooden boats don't like to be stored under the heavy white plastic tarps. Because it can damage, some of the finer woodwork on these beautiful old boats. So that's why he wants to utilize that. The existing greenhouse on the you'll see on the site plan on the bottom left-hand side of the lot. That's going to be used for the storage of masts and tillers and other wooden parts to the sailboats. Ned's, substantial portion of Ned's business is maintaining these old, beautiful Wiano seniors, Wiano juniors, Katuitt skiffs, beetle cats, and things of that nature. But there also would be, some other motorboats stored on the property. I think I hit all the concessions that we talked about with respect to the neighbors. I hope I didn't miss any, but they are here. We suggest to you that the use under the law is substantially less intrusive on the neighborhood than the prior use. We understand that this is a residential use. My client gave all the neighbors a cell phone. I actually gave him mine. I've known Ned since I've been a child. He's a very respectful, very respected person in this community, and we'll run a tight ship. So I'm going to stop and ask if the board has questions, or I'm assuming that some of the neighbors want to provide their opinions with respect to public comment, and we welcome that. But we also, again, will reiterate that we've told them if there is a problem, if there's something we can do, we will try to deal with that immediately, as reasonably as possible. So that's my presentation. Thank you.
Thank you. Anna, do you mind just oh, thanks. Hold on, let me go to. All right, so is there any members from the board that have questions for the applicant here?
I have one question.
Speak up. Yeah, go ahead, Manny.
Yeah, I have one question. Is there going to be any fuel storage on site?
No fuel storage on site other than what might be, in a boat tank. I mean, we're not going to, there won't be any of those small, like, the red 6-gallon cans that, you stick in a whaler or, Carolina skiff. Those will not be on site. But most, I'm a boat owner and, boat fuel tanks are extremely secure. And that would be the only fuel that would be in the boats.
Thank you.
And I forgot to mention one thing. We also agreed with the neighbors that we would conduct operations at between 7:30 and 5 during the weekdays and 9 to 4 on the weekends. I forgot about that.
Okay. Any other board members with questions? Manny,
Yeah.
did you have something?
I did. You just answered one of mine, which was the hours of operation. But the second I had was capacity. How many boats do you anticipate storing on the premises?
We're requesting for up to 75. Actually, I think the lot would probably hold a lot more, but we're requesting 75 boats. Oh, and we're also agreeing not to store anything bigger than 30 feet.
Thank you.
Anyone else? Go ahead, Aaron.
So we're talking about what kind of surface is it's just dirt, ground?
Ground, yeah. There might be he might put some gravel down. There's some soft spots that are soft. He might put some gravel down to harden that up a little bit, but it's going to be completely impervious. There's no pavement going down. Actually, boats prefer, especially wooden boats. Concrete dries a wooden hull out. He says he'll never store a wooden boat on a concrete surface for any length of time, because I guess the concrete just over time sucks the moisture out of the wood. So wooden boats want to be stored over wet ground. It keeps everything moist and it keeps everything tight, and that's the best way.
Will there be a forklift or anything around to all boats will be on trailers, or some will be on stands?
Some will be brought in on trailers and put on stands.
Okay.
You know the stands I'm talking about?
I do. Yep. My boat likes to be on the stones too, just so you know.
No, they do. The moisture keeps them. Yeah.
I'm teasing. I'm just teasing.
I'm not that. I'm just not that bright.
Got you. Yep, that's it. I just was curious about the forklift more so if they were going to be moving boats around once they were brought onto the property for the sake of, again, if it's going to be so tight that somebody shows up in May to take their boat out, clearly Mr. Crosby will be managing that, I'm sure, and whether or not there will be moving boats on property to make other boats accessible, I guess was my question.
Just one correction: people will not be going in there and moving their own boats. It'll only be Crosby Boat Works moving boats on the lot. There'll be there won't be any customers coming in and dropping their own boats. It'll be strictly done by Ned and his staff in a professional manner. And and he also, being a boat owner, boat yards ask you ahead of time when do you want to go in and when do you want to come out. And so if you want to go in early, most of those boats are made accessible in spring, so they're not moving boats around.
Yep, I like it. It's a great response, and that's more to the tune of. To me, this makes sense, but let's hear what the rest of the board and the public has to say, I guess. Thank you.
The board, I've got a few questions. Attorney Lawler, so I see the request as falling under 240-94A and B in the public notice, but then I also see our staff report is referring to 240-94B only. And so I guess I need you to walk me through what is the path here to get to a special permit.
I think it's 94B. I wasn't sure. We had some conversations in the beginning, and I kind of threw a net overall just for notice purposes, just in case.
Okay. So I guess I'm having a hard time with this. So we're saying that this is an expansion of a pre-existing non-conforming use?
Not an expansion, it's actually, it's not a, I guess it's a different, it's not, under the bylaw, if you want, I mean, it's a pre-existing non-conforming use that's less detrimental. So I guess it's a.
But then that kicks us back to 240-94A, does it not?
Maybe maybe it is A. I don't have the bylaw in front of me.
So if we're going through 240-94A, it's saying a change of a non-conforming use to another non-conforming use. A pre-existing non-conforming use may be changed to another non-conforming use only by special permit from the zoning board. In granting this for change of non-conforming use, the board must find that.
I was mistaken. I was remiss not to have the bylaw right in front of me, but it is A. I dyslexized it. I'm sorry, it is A.
It is.
I think,
Okay.
Yeah, it's definitely a change of use because there's no expansion here.
Okay. Our staff report is very incomplete.
No, thank you for catching that.
So I guess I just need you to walk me through it, what the existing use is and when it ceased to exist. Because when I look at it historically, I don't see a landscaping business there. I see maybe some garden operations, but just looking through historic aerial photos, I'm trying to compare what is operated there historically and what was being proposed.
If you look at the decision from the land court, which I have, and I submitted with the paperwork, they made some substantial findings as to the landscaping business. Now, when up until about less than a year ago, that giant mound, when you looked at the site plan, there was kind of a giant round circle. That was the extent of the mulch manure mound on the property. And there were multiple trucks and a landscaping business called Greenland. Was it Green Mountain? Mountain Green Landscaping, operated by the Vieira family for years. The business, though, at the last couple of years slowed down a little bit. It was clearly a landscaping business, pre-existing non-conforming, and businesses are allowed to, within the non-conforming status over a period of time to, sway up and down. I mean, it doesn't have to be, consistent forever. It was a family business. The father was getting a little older, but the son was still in the business, tragically he passed. So that was a situation. But the actual use as a landscaping business certainly was ongoing within the 3-year period, which is allowable under the statute. So any type of landscaping business or any type of business that would require employees to arrive in the morning, bring their cars in, store maintenance, store equipment, have lawnmowers and mulching machines and all this other stuff that they had is far more intrusive to the area, whether it's employees using the bathrooms and people mulling around, vehicles coming in and out with traffic in the morning and in the evening when they leave, and the trucks when they come back and forth or to pick up mulch, to pick up manure. Clearly, those are all more intrusive than literally 75 trips in the spring and 75 trips in the fall. It might be, I might be a little bit more than that, but that's what if they brought one back or for whatever reason. But there's a very limited use of taking these vessels and putting them on the property, securing them on stands, because they'll already be wrapped. They're not coming in unwrapped. They're going to be wrapped by the water's edge. So there's no heat guns, there's nothing. This is just a trailer comes in, backs up, someone gets out, puts the stands on them, they pull the trailer a little forward, they put the other 2 stands on, and they drive away with an empty trailer. And then they repeat that process. And so that's the change of use.
Okay. Yeah. I mean, it's just really hard to establish what the pre-existing non-conforming use is and consists of, because we don't have definitions per se of landscape business and what it entails and what boat storage entails.
Well, I think if you do, I mean, you actually have a court order from the land court that was appealed, and then the appeal was dropped. So it's good law. It's Land Court case number 212935, and it was submitted with my package. And it makes rulings, and it finds that as of 2000, this business had been in operation, and it went through some of the findings as to the scope. Now, some of those have lessened a little bit since 2020, but it continued on up until that point in time as a landscaping business. And I suggest to you that it could, without approval of this board, go back to be a landscaping business, which is more detrimental to the neighborhood.
Okay. Another question. So in the informal site plan review, there's no comments from fire. Is there a reason we have no written comments from fire?
Fire was there, and he said, I just want to make sure, I don't want to put exact words in his mouth, but I believe we just want to make sure we have access and that road is clear. And that there's no intention to put anything on that pavement.
I mean, we've been through this before, and fire was a very significant part of the discussion. We've been through this before with another lot. And so I have a hard time not having something in writing. I don't know the comm chief and where his take is with it, but I know some other village chiefs have a very strong opinion on the storage of boats, the distance they're separated, if there is going to be any tanks of fuel on site, things of that nature. So I personally, to move forward tonight, would have to have something in writing from him saying that it is.
Well, if you remember in the very beginning, I asked that this would be conditioned upon approval by formal site plan, which is scheduled for November 2nd. And in order to get approval from formal site plan, we have to get approval from the fire department.
And is there going to be an updated site plan before that time that shows the actual proposed use, like layout and everything, with boats placed on it and things of that nature, or no?
Boats are going to be placed, we're not leaving designated parking spaces for boats. They're going to be just put in neat rows.
Okay. I mean, again, we've been through this before with this exact same use, exact same situation, and we went through a lot of these different hoops. So I'm just, just comparing apples to apples here. But that's, just one of my concerns there. And we need to be careful that we don't say parking, because I would say if we're parking boats, we are increasing
Okay,
following the bylaw. Any other board members have any other comments before we open to the public?
Just one. Attorney Lawler, looking at the provision of 94 dash, you can open it up, 240-94. So you mentioned the hours of operation. I take it that is less than what the hours of operation were for the landscaping business.
Certainly, the landscapers arrived, before. Before 7:30. I mean, most landscapers are, in May and June are at the shop before 7 and leave and, get to their work sooner. So yes, I believe it is, but I don't know exactly what the hours of operation were of Mountain Green Landscaping. But I can't imagine that a landscaping business would not be in operation before, or certainly at 7:30 in the morning, and working until whatever. But again, the use. I mean, when we talk about use, we're talking about literally backing a boat up and dropping it quietly on the ground and then driving away. I'm not sure that they'll hear anything. We're just literally backing up. There's no. His trailers do not have backup beepers. That was an issue that they asked about. They don't have that. Not required under the size of his trailer. Again, the boats are limited to 30 feet. These aren't big boats; they're small boats.
Yeah, I think Manny's just referencing the bylaw, just checking our boxes here of what we have to.
No. I'm just trying to. Yeah.
Anyone else before we open public comment? Mark, Aaron?
I said when we had our last meeting, my main concern was fire. And I agree. I don't quite understand we need to have the zoning before we have this formal site plan, but fire has only been my only concern, only because it does abut a neighborhood. And again, how they usually, reference how they want things placed within lots, especially something like a wooden boat or anything boats with gasoline, things like that. So that's really my only concern. I'll wait for public comment. Thank you.
Yeah, I mean, I think we are familiar with the.
Yeah, I'm just representing what happened at the informal. That's all. It was just what the comment was, access. That's all. We wanted to make sure the road was clear. I can't, and now if formal site plan is, fire department certainly has the right to expand their requests, and again, this is going to be contingent on site plan. So
Mr. Chair, we can discuss this after public comment, but the idea of having a contingent approval, is that something this board has done in the past? I mean, the sequence makes sense, right? To go through full formal site plan review, have all those various experts, health, fire, and so on, weigh in before we decide on a variance. Is a conditional variance something this board has done in the past?
I think we've done it. The problem is, if anything changes, it brings it back to us, because we can't decide, we can't make a vote on something that we don't have in front of us right now. I look at the site plan it just seems very incomplete for how the use is going to be used. Again, I want to hear from members of the public, but I don't think it very clearly defines the storage area that the boats are going to be encompassing and things of that nature.
If you look at the area, I mean, boats would be stored in that back area on the plan, not within the work line limit. And then some boats would be stored in the front area by the other greenhouse, not on the pave and not within the 20-foot buffer surrounding the property. Again, and the actual upper by zoning is 10 feet. Now, let me explain a little bit why the situation with the site plan. This deal came together relatively quickly as far as this lot. And I think you all know the difficulty in obtaining an engineered site plan nowadays. We were able to track down this gentleman. I hadn't worked with him before, but he had worked on this property years ago and was able to, and he, for an engineer, moved very quickly. And the reason is that it's winter and we need to store boats. And that's one of the reasons why I had conversations with the building commissioner, and he expressed the same things that Mr. Dewey, you expressed, was that there is precedent for this step of trying to leapfrog into site plan review, but but again, if this is change the site plan or whatever, then we probably have to come back, or not probably have to come back to ZBA. But because winter's, I don't want to sound like Game of Thrones, but winter's coming, and we need to, hopefully, if we can get this approved, we need a place to put boats. So that's the exigent circumstances as to why we're here today with this plan at that time. We just literally got the plan fully revised just a couple of days ago, and we made some corrections to it. But with these small boats, it doesn't. That back area is generally where he intends to put boats in a straight line and store them in from one side to the other, and then store 6 Weano seniors within that membrane structure. That's the intent, and then some smaller boats, on the front. Nothing will be, we're trying to work with the buffer so the neighbors can't see them. And if the fire department wants to make changes, then you're right, we have to come back before this board. We prefer not to, but that's the situation.
One last question, Mr. Chairman, just a quick question. Just so I was clear, Attorney Lawler, does the applicant own this property currently, or is this in?
It's under lease.
It's under agreement. Okay.
I don't see any landscaping. I only see a work limit line of 20 feet on the whatever side of that is. I don't know which direction we're going here. it's just really hard. And again, we always have to remember we're granting something that could go well beyond the applicant in terms of ownership and use. And so, yes, that is his intent, but I have a hard time just sort of giving a blank lot and saying, hey, yeah, store boats here, what you just said, wherever we put them, basically, we're just going to scatter them around. Is a little bit scary.
We don't intend to add any landscaping at the point, and we do intend to cut some trees down, but there's no provisions that prevent someone from cutting trees down, just to allow boat storage. Again, other than the neighbors in Hickory Hill, we have a commercial use on either side. And as you can tell from Austin to West Barnstable Road, it's set way back, and there's coverage on either side. There's we generally in boat storage yards, boats are just put in neat rows. And, a boat may go in. One year you might have a 25-foot boat, the next year you might have a 30-foot boat in the same spot. It's a little bit different. It's boat storage. It's general boat storage, and that's how boats are stored on Cape Cod. If you go to any boat storage yard, they back. The ones that come out first are backed into the back of the lot, and then they're landlocked, blocked in by the next boat, and then in the spring they come out in the same order, and that's the intent here. And I did. I mean, when it came to site plan review, informal, granted, they had no issues with that business model.
Okay. And so just like access wise, can you so the trailers are going in forward down the long driveway and turning around back there and backing in to certain places? Again, we've got no turning radius template. We've got nothing here. Or is the access going to go across the abutting residential land?
There'll be, no, the vehicle will enter, most likely coming from Austinville, taking a right-hand turn into the driveway. It'll proceed up into the driveway. As you can see in the garage area, the driveway is larger. The boat will do some type of 3-point turn in front of the garage or in the back lot. And then it'll back into the space that abuts the nursery for the first, and then put the boats in a row there, and then repeat that process until that area is full. Does that make sense?
So we have edge of pavement marked on here that crosses over the residential lot, correct?
I believe there's an easement that allows that. So yes, there is. That edge of pavement does cross into the residential lot. Yes.
Okay. So I don't know. I still think we're rushing this. We're pushing this, and we've had a lot of these kind of inquiries for things of this nature. It's a tough place where we live on this sandbar. But I guess let's open it to the public and bring it back to the board for discussion.
And from a public good standpoint, I mean, again, we're a marine community. We have, and I'm not criticizing the planning department, but there's all this zoning going along that, and then some of these essential, what I refer to as essential uses that aren't perfect. I mean, it's almost like, we have all these beautiful homes, we have all these beautiful areas, we have these beautiful boat yards, but you need places to have contractor yards, you need places to have landscaping yards, and you need places to have boat storage. And this happens to be one that's pre-existing non-conforming with one of the other uses, a landscaping yard. And we suggest to you that the real standard here is this, is a pre-existing non-conforming use. The legal standard is, does this become more detrimental? And as I said in the beginning, there's nothing that's more detrimental about this use than the prior use. Because generally when you look at detriment, you look at traffic, you look at septic, you look at water use, you look at you look at, in this case, odor. Okay? Those are the things that essentially the senses that a person has. Those are the things that generally lead to detriment. Here you have virtually none, other than the, might there be some, site may not look as pretty as the landscaping yard. Yeah, you could argue that. But if you overall and you weigh the two scales compared to landscaping yard and the detrimental uses at a boatyard, and with respect to the sight lines, we're keeping that 20-foot buffer with the trees, and we've told the neighbors if they have a problem, we'll put another one in. And that's the intent, is to keep it so that they don't have to be bothered by this particular use. It's a very, very benign use.
Is boat storage allowed in the wellhead?
It's not prohibited. Doesn't mention it.
Okay. And will these boats have copper-based paint on them?
Ned?
They will.
Some of them will.
Some of them will. Okay. Let's open to public comment here on this. I don't think we have anything in our file for public comment. And is there anything received?
Nothing received.
All right. So we'll open it up to members of the public that might be here to speak to this. Just unmute yourself and make yourself known, and feel free to speak up. No one? David, do you know if anyone was here intending to speak to this?
Yeah, they were. I don't know if they're intending to speak because we met with them today. I know obviously they're very interested in.
Oh, sorry. I was asking David at Channel 8. I didn't know if he had let people in with saying they had.
Hold on. Sorry. I did not encounter anybody that was here to specifically speak to the item, but if anyone is here to speak to this item, now is your time. Not hearing anybody.
All right.
I do notice the name of two. I don't want to say their names because they chose not to speak, but I do notice at least two of the people we met with on the chat room. So obviously, I'm representing what we talked about. I would assume that that's the case.
Okay.
I'm happy to speak for a second.
Go ahead. Just say your name and address for the record.
Yeah, Rob Zinman, 250 Hickory Hill Circle.
Yep. Go ahead. Just go speak whatever.
No, we had a nice conversation with Ned and David multiple times. Went to see the site. I think most of the neighborhood that showed up felt pretty comfortable. I think the questions you just asked, Jake, definitely were relevant to us. But overall, the relationship was very, very positive, very cordial, and we appreciated their time showing us everything, and they addressed most, if not all, of our concerns. So
great, thank you. I appreciate you speaking up. Let's leave public comment open for a minute, just in case anyone from the board have any thoughts or discussion.
This is. I'd like to chime in. This is Rife Boston, 281 Hickory Hill Circle. I just wanted to make a quick comment regarding how the boats are being put in. It's kind of to support what David just said, where it's difficult to do a lot layout of where every single boat's going to go. And yes, I agree with what David said as far as how the boats are coming in and going, and it will be more of benign use of the property than what we have experienced in the past. And they have been very forthright. So that's all I got to say.
Thank you very much. Appreciate it.
Rife and Rob, thank you very much.
Anyone else? All right. Anyone from the board have any comments? I guess one question, Attorney Lawler, are these houses, and maybe members of the public can answer, are they all served by public water, town water? No one's on a well?
I don't know that, so they'd have to answer. I don't know.
Town water.
Okay. Anyone from the board have questions or comments?
I have a quick comment, which is that, again, hearing from the two neighbors, the last gentleman in particular, talked about less of a benign use. It sounds like, the Attorney Lawler and his client have done their due diligence to get out in front of the neighborhood and, be there to, assist when and if any issues come up. And I think that the neighborhood sounds to me like they are in support of the considering what's been going on there previously and what the petitioner is asking for. So I thought that was pretty positive, considering that the last time the Attorney Lawler faced us, he was made it clear that there was some conversations that needed to be had with the abutting properties and so forth that might be affected, and the group that showed up to do that sounds like they got things resolved. So I give them credit for that, and that's my only comment.
Anyone else? Mark, Herb, Manny, Larry?
Quick question. If we were to, and again, this goes back to probably more fire department, but is there any detriment to just not saying the allowable amount of boats and having it determined by fire, or is that kind of counterproductive? I mean, does that not change anything?
I mean, I don't know. I don't know what fire. We went through it. We went over this in West Barnstable, and there was a very clear layout of where and how the boats were going to be and how access was and turning radiuses of the truck and trailer to make sure how they could be accessed, and the truck could turn around in there. We weren't driving on neighbors' properties and things of that nature. So I don't. Again, I feel like we have a very small sketched plan that doesn't really show the business of how it's going to operate. But
every other project that runs through here has a site development plan that at least shows. I mean, I sort of get it, but I mean, if you take the boats part out of it, it's rare that, I mean, granted, they're going to go back to formal site plan, and you're still at that point, correct, not going to have a full site plan available. Is formal site plan willing to accept the current, what we're being presented with tonight? Are they willing to accept that in order to move forward?
I submitted it to site plan. I haven't heard that they aren't. I mean, obviously, if they aren't, then we have to come back before you because it's a different plan. So, again, this is it shows every structure on the spot. It shows everything except exactly where the boats are going to be. And that's, there's no, when you look at that giant octangle or whatever shape it is, that was the manure pile. That was there's still just remnants of it, but it's all been taken away, hundreds or not thousands of yards. It was 20 feet tall. That and, the new proposed structure on the back of the lot, it shows the existing structure. There's not a lot on this lot. It's a flat, very accessible lot with mostly grass and some trees in that back corner.
And just a quick question. So I know that the fire department is going to be looking to say that they have access, and it looks to, just in general, looking at the scale of what you presented, that the road is about 20 feet wide. Did they make any indication that, because you're pretty tight on there, is there any indication that would not be wide enough for something to come down? I mean, obviously boats and things are of that nature, but is anything that was mentioned at informal site?
No, I mean, that's exactly what was mentioned at informal.
Okay.
All he said was, you gotta leave the road clean and we need access. And that's the access that we will leave.
Right. So he would be able to turn around in there at all times when 75 boats are there and get back out, or he has to back out to the main road?
We'll be able to turn around. I will obviously have to leave a place for them to turn around. That'll be a question, but yeah. Because I think they can turn around in that pavement, in that paved areas. We're not storing boats on the pavement. And obviously that'll be, that actually probably should be added as a condition. No boats stored on the pavement.
And then in terms of the structure, the new structure that's going to be built, is this considered a temporary structure?
It's essentially was Ned used to have his storage over in West Barnstable, and there was an existing greenhouse there. And the application actually says by 90 feet, but it's in 3 segments. We're only intending to use 60 feet. And when he left there, he removed the structure, intends to put it back up. And it has, I believe a greenhouse would probably constitute a temporary structure. Now, that's probably up to Brian Florence and the building commissioner to determine that. But it's a structure, let's call it a permanent structure. It's there. I mean, it's what we intentionally placed it 20 feet from the sidelines, which is double what the zoning requirement is. We're trying to be as polite and respectful to the neighbors as possible.
Okay. And was there comment informal about the structure?
No.
So the fire department has no concern about boats being stored inside the structure?
Well, they have been in the town of Barnstable already for the past 10 years over in West Barnstable. Now, obviously, it's a different fire department, so I can't.
Okay. Yeah, again, just having been through it, unfortunately, I know the ins and outs of what these fire marshals.
Yeah, maybe there's going to be. All I can tell you is what happened at informal, and it was not raised as a big concern. Now, does the fire department have the right to raise it as a big concern? If that happens, then we'll probably be back before this board on that one particular issue.
Okay. And if we condition this with that nothing can be, trees, nothing can come down, that's fine. You guys don't need to take any of the trees down on the lot?
No, we're taking a bunch of small trees down.
Okay, I thought you said earlier that you said that.
Not taking any trees down in that 20-foot buffer zone on the right-hand side. That's very heavily wooded in that section where that 20 feet is, and we're leaving all those there. That's providing coverage for the neighbors so they can't see the boats.
Okay, but so, I mean, again, we don't, this plan doesn't even have any trees stamped on it that exist or that are going.
I mean, that whole back section there's a lot of trees there. A lot of the smaller. He's not intending to take the big ones down. It doesn't make economic sense, except for 2, which are dead. And those will come down. Those would be coming down anyway. Those are a hazard. Actually, I think the neighbors, one in particular, would be very happy if that came down because I think it would take out his backyard. Yeah, no, I mean, the boat was the boats from that area, to the, is it the north, east, facing, from Hickory Hills to Barnstable, West Barnstable North. I mean, anything in that 20-foot buffer is going to remain untouched. And my client will have the right to cut the trees in areas not within that buffer, but his intention is not to cut all of them by any stretch.
No, I disagree. Respectfully disagree. That's not the way the bylaw reads, though. I don't think you can take down any trees. You need to operate within the footprint of the pre-existing non-conforming use.
I disagree. You can cutting down some trees does not. That's not a. There's no requirement that you can't, if you have a pre-existing. The prior applicant could have cut down the trees at any time.
I understand that. He definitely could have, but I'm just looking at 240-94.
It doesn't say anything about
what's for us.
Trees. I mean, trees grow and die and fall. It's not like we're going in and making alterations to any structures or any other. A pre-existing non-conforming business can grow and adapt. This is just one change of use to another. It's not as restrictive. I respectfully disagree with you, Mr. Chairman.
In item E, it says does not expand the gross floor area. Well, we're talking about outside area here, so that is our floor area.
But that's floor area. Floor area is a structure, not. There's no question. The floor area is intended as a structure. This is outdoors.
Nope. If I may, Mr. Chairman, but it goes on to say does not increase the number of non-conforming uses on the site. To the extent you're removing trees, you're expanding the non-conforming use.
If we went through this with that car place not that long ago.
Over in West.
Well, I'll be back with you on that soon. But this is a change of use, and the change is on the entire lot. The area where there was manure stored is now going to be storing boats. We removed, truckloads and truckloads of manure and compost and mulch. Are you suggesting that by doing that, would that change the lot? I mean, that was the prior use. It's a change. Now, whether some trees come down so a boat can fit in that particular area is, it does not in any way affect floor area or anything like that. And it does not expand the overall use. You can't look at each individual component as an island by itself. The board's duty is to weigh the prior pre-existing non-conforming use and compare it to what is being proposed. Because obviously there's going to be differences. We are going to be removing hundreds of yards or 1,000 yards of manure and mulch and putting some gravel down on the dirt to firm it up because of the manure, and put boats on top of it. We are going to cut some of the smaller trees so we have access and turning ratios. That's no different than removing mulch or manure. There's no expansion of floor area because we're not touching any of the existing structures. Though we're asking to putting in a greenhouse. And there were 2 greenhouses on this property within 3 years. So this is the standard is this more non-conforming? Is this more detrimental? That's this legal standard. Not are there changes? Of course there are changes. We're going from a change of use, which by its very nature means that certain things will be different on the lot. And that's the law, and that's the standard, respectfully.
Any other board members have questions or comments or thoughts?
Hi, Herb Bodensee. I'm looking through, I have to confess, I didn't read all 30 pages or whatever of the land court decision. But unless I was able to read that pretty thoroughly, I don't think it's a change of use. Personally, I don't know if you want to ask the other board members what their feelings are by change of use in terms of cutting the trees down, expanded use, maybe you were calling it, but I don't have a problem with it.
Okay.
Wait, I'm sorry, Herb. So you don't understand that it's a change. It's a change. It's a different change. It's a change of use, but you don't have a problem with it. I'm confused.
No, I mean it's a change of use.
Yeah,
but the issue is cutting down some trees and saying it's an expansion of the pre-existing non-conforming use because it's taking up a different part of the land area of the site. I don't think, if I read through the land court decision, I don't think there's going to be any mention of restrictions to certain parts of the lot. I could be wrong. I'll get back to you.
So just to get back to it, you're in favor?
Oh yeah, I'm in favor.
Yeah.
Pending, of course, fire department, cooperation with the fire department regarding, placement, configuration, et cetera, of the boats.
I don't want to kick it down the road either, the site plan. But again, the petitioner has said to us, we can approve it with the condition that it passes formal site plan. So I don't know really what we're doing here. We're talking about cutting trees down. I mean, really, is this what's the issue? I don't see an issue here.
Yeah, I don't think
Again, I haven't been on one of these before, Mr. Chairman, so I do appreciate what you guys have been through and some of the precedent you've seen thus far. But to me, this is pretty straightforward. And in fact, it's the neighbors who abut the property that had any issue, if there were issues, say that it's a better use than currently what's going on here. So what are we talking about? I mean, the petitioner
again, Aaron, I go back to what I said earlier. You have to remember that we are making something that can carry on into the future beyond this. I think we have to be very careful how we condition this then. I mean, are you okay if it becomes 20 motorboats or 50 motorboats? I mean, we're limiting it to 30 feet of length is what's limited there, but we aren't limiting whether there's, 10,000 gallons.
The petitioner's, he's asking for 75 boats.
I know, it's a lot.
Yeah, but again, the space is going to dictate, Mr. Chairman, whether or not it can happen, and his ability to, obviously, as he's indicated, and I have full faith in what Attorney Lawler indicated, that there's not going to, people aren't coming onto the property. The only people coming onto property are the petitioner and his staff to then, take a boat from storage and bring it to the waterfront. And that's all that's happening here. All the work's getting done. Again, I mean, if there's complaints from the neighborhood, we'll go to Brian Florence, the building commissioner. He'll come out and do a review of what's happening on the property. And so there are steps in place that protect the public from the use being expanded upon over time. Right now, we're talking about boats.
Then we have to set that. We have to set those parameters for Commissioner Florence to go by then of what it is. I mean, they could put rack storage in there and have 75 boats 3 levels up in the air.
And I appreciate that. And I wrote in the staff report today that came out to us said you can condition it that no rack storage can go on.
Yeah.
Again,
so again, we need to think through those items of, okay, what they are, so Commissioner Florence can protect the residential neighbors that live there for a future owner that is operating a different kind of business. Again, you have to think to the future. Are we going to be
Mr. Chairman,
boats that have 10,000 things of batteries in there that we just went through? I still am getting beat up over the solar thing. That there's the chemicals in the solar that are going to catch on fire and they're going to kill all of our children. So we have to think about that and how we condition it.
Yeah, don't confuse the issue.
we agree that you're getting beat up over solar doesn't mean that this guy can't put boats on an empty lot.
I'm just saying we need to make sure we condition it properly to protect the public that surrounds the area.
Okay, well, let's work on those conditions.
If I may, Aaron, we never thought about rack storage. We have no intent, and we're very comfortable with a condition that says no rack storage.
Perfect, thank you. What other conditions would we like to have in there?
Mr. Chair, would you like to close public comment or leave it open?
I think we can I'm fine to close public comment if no one has any objection to it.
Well, I do have, I did find one thing in the land court decision. I'm on page 10 out of 30, but actually page 9 out of 24. It sounds like there was they were growing trees and bushes and things like that. So maybe these trees that are being talked about, and it sounds like a minimal number of trees, were part of the actual use that was pre-existing non-conforming. So it's on page 9 towards the bottom of the page.
That actually works for me, Herb, but to be truthful, they're just some of the white pines. They're not.
When it's agricultural use,
I appreciate that. Yeah, no, I don't want to mislead the board in any way. There's some small white pines, or medium size. The big ones are going to stay. Except for the there are, like I said, there are 2 dead big trees that have to come down.
I'm going to make a motion to close public comment. Do I have a second?
Second.
I'll second that.
Herb Bodenseek, all those in favor? Herb Bodenseek, roll call vote.
In favor.
Mark Hanson.
In favor.
Aaron Webb.
In favor.
Larry Hurwitz.
In favor.
Danny Alves.
In favor.
And I'm also in favor. So public comments closed. That brings it back to the board. If you guys have someone wants to make findings or any more deliberation? Mark, I think you had something you were trying to say.
Yeah, just that I just wanted to mention because it's here and it was suggested by staff, as well as the racking of boats and setting a height limit on that. That one of the suggestions from staff was to have a set defined area for boat storage, as one didn't exist on the plan. So again, I don't know. I think it's hard to look at the plan and really in everything else that we have. And I understand the timing of it. I get that. And I truly do. And I deal with site plans all the time. And it's just, I've never been able to have anything approved when there wasn't something there. And I understand that it can be rows of boats and whatever the case may be. But once we set just a number, it doesn't set any sort of parameters about where on the lot, how they are on the lot. It doesn't take into consideration, obviously at formal site plan, fire will they'll make their recommendations. But if it comes back to us again, I don't know how we've saved any time other than we wouldn't have to go to another meeting after formal site plan. So it's just the lack of seeing where things might be here is what has really my only concern, but I don't necessarily have an issue.
I could read a suggestion condition. I could give you a suggestion condition that would define it, I think, fine. If the board would be willing to.
Go ahead, Attorney Lawler.
Go ahead.
I would suggest that the boat storage be in two locations. The first would be in the rear of the lot behind the existing garage, and not to be stored within 20 feet of either side or rear setback. That would define that entire back area. And then to the in front of the garage, no boats to be stored on pavement and may only be stored between the pavement and the 20-foot side setback. And that would define it to be in those two particular areas, and I think it would define it fine.
So are you saying there'd be like a 20-foot limit of work all the way around the rear part behind the garage?
Yeah, 20
on
feet.
all sides.
Yeah, 20 feet, and that would, yeah. And then, and the front portion would only be stored from the pavement to the 20-foot line. I think that existing greenhouse goes over it by about a foot, but we can't move that. But if that would define it perfectly, and that would be more than enough room to store 75 boats. Remember, some of these are 10-foot little skips and stuff.
What is inside that 20-foot buffer? Is there would remain natural trees? We're going to plant more trees, create a fence.
Right now, they would be untouched. And if the neighbors, I know one of the neighbors who spoke, Rife, said, if there's a problem with the sight line, would you throw up an evergreen? And Ned said he absolutely would. So we would not, we would agree to not cut down any vegetation. We also, we don't want it growing like weeds and everything. He wants to maintain it so it doesn't look bad, but we would not cut down any trees. He certainly would cut the grass in and stuff like that in there.
Right. And what's the maximum height of the temporary structure?
I believe it's 16 feet.
Okay. Is that something we can condition that no structures are higher than that?
Yeah.
Okay, I'm just looking out for the neighbors.
I understand. Yeah, I understand you're not doing it for my client. You're doing it for 20 years from now.
Yeah. Is it a hoop tent? What is it? Is it?
It's an old greenhouse, Mark. It's an old greenhouse. Not an old greenhouse. It's a greenhouse.
Which is like a hoop tent.
Oh, I'm sorry. He knows. Yeah. Okay. I'm a lawyer. You're a builder.
The height limit sounded low for what you were trying to put in there. That was why I was asking. Is it like straight sides and then it's like swooped or?
The masks are taken off, so there's no. So when we added, those are specifically intended for Weano seniors. They're about 24 feet long, and they go in rows of 3. So they would just be side by side. And I think a senior is probably only 4 or 5 feet tall.
It's probably more like 9.
Oh, 9 because of the keel. Yeah.
Yeah.
Yeah. So they're 9 feet tall. Wasn't thinking of the keel.
Okay.
And then I guess another sort of concern, following some of the things we've seen, will all of the boats leave annually, or at least
there might be a couple that stay for the summer.
Okay.
Yeah, someone says, you know what, so and so got sick. I don't want to put my boat in the water this year, And then in the summertime, there'll be some trailers stored there. But those will be, I spoke to Ned and he actually brought up to me, I mean, he has neighbors, he wants to maintain this. He doesn't want any problems. He's going to neatly store trailers. And if a neighbor has a problem, he gave him his cell phone, pick it up and call him.
Yeah. Again, it's just, we have to think about the future of who.
I understand.
Whatever. And I don't want to become a boat junkyard.
I mean, it doesn't make sense to have boats stored there in the summertime because it's boat storage. It's not to throw away boats. It's not to, these are functional boats. I know.
Aaron, does anyone else have any comments? You guys, does Aaron, do you want to make findings? All right, Manny, do you have anything you wanted to add? Sorry, I don't think you added anything.
I'm okay. I mean, I think with the conditions that have been put on the table, I'm a little troubled by doing this contingent on what we hear, because I think we may be coming back here. But I think I'm okay. I can make findings and ask others to weigh in.
I just have a quick question. When we talked about a 16-foot height for the structure, we're not talking about boats. We're talking about hoop houses.
Correct.
Okay, gotcha. Okay,
Yeah.
that's all.
Just because, Aaron, the reason I brought that up was because they make these hoop houses that some of the Chatham marinas per se have that are like 40 feet, 30 feet up.
Yeah, no, I 100% appreciate that restriction. I thought you were I wanted to make sure we weren't, combining the two together, because 16 feet for a boat is not high enough on stands and everything else. Okay, good enough.
And Mr. Chair, just a point of clarification, we're here under 9.4A, right? We've established that this is not an expansion, it's just a change of non-conforming use.
I believe so, yeah. So I would say that we sort of need to update the staff report as we read it in, and it was noticed, the public notice had both 94A and 94B in the application.
And I think too, because of the structure itself being most likely temporary in nature, it doesn't increase any footprint on the lot.
Agreed.
Correct. That's what yes.
All right.
And in the staff report, it says 90, it should be 60 when you read it. 60 by 30.
Again, not to argue this point to death, but the fact that we're increasing the space within which the non-conforming use will be conducted, that is, by taking out some trees, leaves open the question whether or not this is an expansion.
I agree. That's basically what's before us to decide.
Because if it is,
I think you can approve it under both A and B. To change and if you want to call it an expansion, I'll leave that to the board. But I want clearly the parameters are set forth of what we've intended to do. We've been, extremely transparent, and I'll leave that to the board if you want to approve it under both.
Well, Mr. Chairman, what if I know this sounds kind of extreme, but if they are in fact just small white pines, then it could be that for every one that is removed out of the general area in which they're going to operate, they could replant one on the perimeter, as far as say, towards the properties that are on West Barnstable Road. I mean, again, if it's not that much, then I can't tell because I can't see what would be taken out and what is going in. If it's in the working area and if you're truly not expanding, then you're taking one for one. You take one out, you place one somewhere else in in a buffer zone, if that's the case. I mean, this is we don't have to guess, but somebody has to figure out what that is. We don't know.
Yeah, again, we don't have existing conditions and proposed conditions, which ideally that's what we would have for plans to be looking at.
There could be 100.
This is not in the conservation zone, so I mean, you're allowed to take out plants, and don't get me wrong, we're keeping the larger, healthier trees. Quite frankly, kind of going in and taking out some of those smaller scrub white pines is probably beneficial to the bigger trees.
I'm just trying to assist in the language of expansion. That's all.
Okay.
Without having, you're not putting it in front of us. So you're asking us to visualize what we think that may be based on your description, which your description may be 100% true. But again, we're trying to work off a plan that is not an as-built. And it's rare that we do that ever.
And I appreciate that. Thank you.
So Manny, do you want to make findings?
Yes, so based on the conversation we just had, are we following the staff report by going consistently under A and B?
I mean, the public notice was A and B. The staff report is really answering to B, is how it's written, as drafted.
Yeah.
That was why I brought that up with Attorney Lawler at the beginning.
Yeah, it does reference both, though. If you look under conditions, this is for A and B.
But findings are referencing only B, right?
Yep, agreed.
We can only determine, because it says that the site development shall be constructed in substantial conformance to the site plan entitled Site Plan for John Vieira. So we can only assume that it's going to be constructed in the way that we see it currently.
Which shows it with 0 trees, correct? Am I looking at the plan correctly? There are 0 trees on the plan? That would essentially give them a right to clear cut the lot?
Correct.
Is the board comfortable with that?
It says limit of work, but it doesn't. We could add that trees along that line must remain as a 20-foot buffer. That nothing existing can be cleared inside of 20 feet from the lot line.
Well, Attorney Lawler suggested conditions that 20-foot limit of work would continue around the side, the north. East side, I guess it is, where it abuts West Bay Development, as well as the Carolyn Dalbia property there on the west.
Okay.
Attorney Lawler, does that start to get a little tight in there for you guys?
Yeah, I think it's, the 20-foot buffer shown on the Hickory Hills area, and then, and then in the back portion of the lot, we're okay that with Carolyn. We're not going to put that area is clear already. There are no trees there, but we're not going to store boats within that 20-foot area. So I would certainly, and there might be a tree or there. I think it's clear. That could be other trees over there. It's sprinkled about a little. They're sprinkled about, but the certainly. Some of these large pines, probably have like a 12-inch caliber. You could put a condition that we're not going to cut any healthy, trees with greater than, say, called a 14-inch caliber or something like that. If you want to put that as a condition without, but I don't want it to be coming back every single time we want to cut a tree down to get site plan review approval.
It's not even you can't put Brian through that either.
Yeah,
we could require that the lot be fenced on some sides too, if you guys think
it already is fenced on that entire the important side.
On the north,
on the Hickory Hill side, it's all fenced. It's a 6-foot stockade fence that runs the whole length.
And it shows stockade fence on Carolyn Delumbia as well.
But there's nothing on the Oster West Barnstable side between 160 and 140 currently.
Yeah, but those are the owners of the lot.
I know. I'm just looking.
That's wide open. Yeah.
And then I'm also just looking to make sure we're keeping the commercial nature of this use on the parcel that we are giving.
We are not leasing that other property. There's no intention. We have no rights to that property. It's not the land, and that's clearly indicated. There's no intention whatsoever to store anything on their property. That's a residential lot. That's not part of the decision of the land court.
Attorney Lawler, did it say that there was, is there a written easement at all on the bend in the road there?
I didn't do a full title, but I can't imagine there isn't one, but I don't know. I did not do a title.
Okay.
Certainly we have permission, and I can, Mr. Crosby has been friends with the owners of these lots for 50 years. I can't, we'll look into that, and I can't imagine one will not be given if.
It was just a thought, well, it exists, or if the friendship exists, or whatever it is, because of.
Yeah, no, that's a good thing on the lease. Obviously, under the lease, we have full access, and that provides that, so. And it's with the same owner, so. That's actually a good point to look into. Thank you.
So Manny, do you want to try to make findings here? I mean, I guess we just need to reference 94A and B, but I don't know. I lean more on B here. Or on B.
I think I do as well. So I'll make the findings. So this is on application special permit number 2023-029. Let me go here. EM Crosby Boat Works, Inc. has applied for a special permit pursuant to section 240-94A and B, change of or expansion of a pre-existing non-conforming use. The applicant seeks to change the use from a landscaping business to a boat storage business. The applicant proposes to store up to 75 boats on the property. Also seeks to construct an approximately 30-foot by 80-foot structure covered with a clear membrane to be utilized for the storage of wooden sailboats. Subject property is located at 140 Osterville, West Barnstable Road in Osterville, Massachusetts. For special permits, the board is required to make general findings pursuant to section 240-125C. The board should review the evidence presented by the applicant, staff, and members of the public, and after weighing such evidence is encouraged to articulate if and how the evidence contributes to each of the required findings. The application, so these are my findings. The application falls within a category specifically accepted in the ordinance for a grant of a special permit. Both sections 240-94A and B allow for a special permit. After an evaluation of the evidence presented, and the proposal fulfills the spirit and intent of the zoning ordinance and would not represent a substantial detriment to the public good or the neighborhood affected. My findings are that based on the evidence presented and the testimony, that the frequency of use of this lot will go down substantially. As has been represented, the boats will be will be brought in, stored, and then sometime later, the boats will be brought back to their owners. There'd be no activity within the lot in terms of either doing maintenance or woodwork. And that, I think, contrasts sharply with the operation of a landscape business where the back and forth, the storage of noxious materials and so on, would have been more detrimental. So I do find that the proposed change in use would represent a decrease detriment to the public good in this regard. I'm also persuaded by the testimony of the public at this meeting who are persuaded by and have had conversations with the applicant and seem to agree that the proposed use would be less of a detriment. I find that a formal site plan review has not been conducted, and that the decision of the board ought to be conditioned on a favorable, approved site plan review, including input from the fire department. Absent such site plan review, this matter ought to be brought before the board for additional proceedings. Under 940A, 240-94A, I should say, I find that the proposed non-conforming use requires no more parking than the previous use. does not generate more traffic than the previous use, does not result in an increase on on-site and off-site noise, dust, and odors, does not result in an increase in the hours of operation or in the number of tenants or employees, does not expand the gross floor area of the non-conforming use, nor does it increase the number of non-conforming uses on the site. It's on the same lot as occupied by the current non-conforming use and does not expand beyond the zoning district in existence on the date it became non-conforming. In addition, under 940B, I find that the proposed expansion conforms to the established setbacks, or such greater setbacks as the board may require, and we'll get to that in the conditions. As I mentioned earlier, I find that the proposed use and expansion is on the same lot as occupied by the non-conforming use on the date it became non-conforming. The proposed new use is not expanded beyond the zoning district. I think I said that already. And I'll seek input from the board, from Mr. Chairman here on number 7, because we didn't get into a lot of these, but we didn't talk about signage. I find that there will be no additional off-street parking and loading facilities, and the proposed, and this will appear in the conditions, increasing of open space or vegetated buffers will be, I guess, useful and lead to the additional detriment to this proposed change and expansion. Mr. Chair, I welcome input and suggestions.
Any board members have any thoughts here? Anything you want to add in the finding?
Not in the findings, I don't.
Okay. So we need a second for Manny's motion with the findings as presented.
I'll second.
All right. Roll call vote to approve the findings as presented. Herb Bodenseek.
In favor.
Mark Hansen.
I'm in favor.
Aaron Webb.
In favor.
Manny Alves.
In favor.
And I'm also in favor. So now I think the tough part is how to condition this, or how we want to condition it. I have some thoughts, and others have thoughts. Attorney Lawler, are we comfortable we're abandoning the landscape use as?
Let me just talk to my client real quick.
Okay.
The concern about that, Mr. Chairman, is my concern. Can you hear me?
Mm-hmm. Yep.
We're a tenant. We don't own the property. They went ahead and obtained a court order with respect to the landscape use. I don't think we have the authority, and I just don't think it would be the right. I don't think it would be appropriate. My client is friends with that family, and I don't have.
I think that puts us in a really hard position then.
No way.
The intent of the bylaw is to go to something that is less detrimental to the neighborhood, and you presented that this is less detrimental to the neighborhood.
After 3 years, that probably would happen anyway. So
then your client's okay with it.
When is this property supposed to change hands? If you get the approvals you need, is this being
immediately upon approval of the board?
But it's
It's a lease agreement, Mark.
It's not a sale.
correct.
Oh, I see. Okay. All right.
So, do we have the right parties here? Because this would run with the land, whatever we approve here.
But we have the lease, and we have the authority to file the application, and the owner gave us the authority to
let me run a
That's
scenario.
the end of the lease.
The lease gets terminated next week for whatever reason, just a hypothetical. And the owner decides to revert back to landscaping. We're right back here.
Well, I think
within the next 3 years, and then after that, then it would be that would be a different story.
I mean, Manny, we can condition it. I guess we can negotiate that we condition it that they have to come back to the board for permission to revert it back to landscape use, and again provide us with plans. I mean,
yep.
I have a problem with
the whole lot could be cleared for boat storage the way we're allowing this, and then landscaping becomes much larger intensive use than the existing landscaping.
I have no issue, no issue with that at all, because they would have to do that anyway. So, yeah, none whatsoever.
And then no additional structures. Are you okay with that, other than the what's been proposed of the hoop house or the greenhouse?
Without coming back to the board.
Okay. Is there water there? There's existing water supply?
Yeah.
There is? Okay. And there's bathrooms?
Yep.
And those are going to continue to operate?
Yes.
Okay. Will there be any vehicles parked there at any time? Do we need to have vehicles? Like, is the truck and trailer going to sit there in the wintertime or things like that?
There's no intention. I mean, there certainly trailers will be there. No question the trailers will be there. I mean, I don't want to say we can't leave it. There's also that, because it's a residential use, that I believe there's an apartment. He has no intention of using it. There's an apartment in that structure. That's a resident. That's allowable by use. It's a residential area.
But mixed use isn't allowable there. Residential, yes.
That's pretty.
I'm just trying to figure out the parking situation. If we're parking,
I mean, we're not. I mean, we're not intending to leave vehicles there. But I mean, if he has a truck and he wants to leave it there for a couple of weeks or something like that, I don't want to pretend. They would be. He's not intending to store old cars there. I mean, he's not intending to store. There'll be no. How about this? There'll be no long-term storage of vehicles on the property. He might. I think that would. Storage. I mean, if vehicles come and go, and I'm not going to ask him that you can't leave a truck there for the weekend and then come and pick it up on Monday.
Again, I'm just looking at future use that a boat hauling company or something has 10 trucks there and 75 boats parked around them. And I just don't know that that's what the neighbors are getting themselves into.
Would limit it to 3 vehicles, no storage of unregistered vehicles on the property.
Okay.
Is that fair?
Yep. And then just like we discussed this, how would you like to word this, the use, the lack of work there, washing, working on boats, et cetera? I don't know what the right.
No boat maintenance or to be performed. No boat maintenance or repair to be performed at the site.
Okay.
Yeah.
And then,
so that.
I mean, number 4 says the use is for boat storage only. I mean, is that not?
Yeah, I think 4 does it.
Okay.
The revised 4.
No additional uses are allowed, including but not limited to maintenance and repair boats without an amendment to this permit. I think it's there in 4.
Okay. Good.
So,
is there a plan to increase any impervious area, or no? We're keeping the same impervious.
Yeah, we have no intention of increasing any impervious area.
Okay.
And are we saying no rack storage, or are we saying no rack storage above 1 level?
No rack storage.
No rack storage. We're putting things on those the blocks and stands.
Okay.
So I can start with the conditions, and please others may weigh in. So Attorney Lawler, the conditions numbered 1 through 6 in the amended staff report updated October 25. We'll start there. Are you okay with those?
I am.
All right, let me take that. And I'm going to say what I heard in the additional conditions will include hours of operations from 7:30 to 5 during weekdays and 9 to 4 on weekends. not to be exceeded.
Mhm. Yes,
No flood or no flood lighting on the property. Again, I'm not sure if that's the technical way to frame this, but is that something your client would be willing to accept?
yes. That's what we agreed to with the neighbors,
Okay. No rack storage.
correct?
No maintenance
Correct,
of, I was just going to say, long-term storage of vehicles on the property or maintenance of unregistered vehicles.
correct,
Obviously, a big condition is that you obtain approval from a formal site plan review.
correct.
Attorney Lawler, just a quick question while we're on that. Are they requiring you to get an updated site plan? Was that part of any conversation during informal?
I submitted this to site plan review when I got it, and I have not heard a comment that this is not acceptable.
I don't think they'll respond, Mark, until it's at the meeting. They
Yeah,
could
fair
kick it
enough.
right back at the meeting and say, come back with this, and this.
So you okay with number 2 as it reads, or it?
Evaluation of all evidence presented proposed number 2. Hold on. The site plan development shall be constructed in substantial conformance to the plan entitled Site Plan of John Vieira with the last revision. Yeah, I mean, site plan development shall be constructed in substantial. Yeah, I think substantial. I mean, the minor changes, I think substantial would be fine. I think if this board, if there's major changes to the plan, I think this board would want us to come back, I'm guessing. Would you
Can we say anything like the whereby the 20-foot existing limit of work shall remain untouched with regard to vegetation?
I actually was going to put that in as a condition, yes.
Yep.
That the 20-foot, that there would be no boat storage or work in that area, and no clear cutting. I mean, again, some of those areas don't have, has grass and weeds. I'm not saying that it's going to be untouched, because I don't think the neighbors want it untouched. Otherwise, it would grow and it would look awful. It would be maintained in its present condition, substantially in its present condition. I think that would be the right.
Or shall remain as a significant buffer? I mean, I don't know, something.
That's fine. Yeah, whatever. I just don't want to use the word. I don't want to use the word untouched. It's not like it's in the wetland.
Understand.
So just so I'm clear, looking at the site plan, this is that dotted line. Well, I think it's noted limit of work on the east corner of the lot. All right.
Right.
That runs all the way across. Okay. So Mark, what was the proposed condition?
Oh God. It was that last revision date of October 23, 2023, whereby the proposed 20-foot limit of work shall remain substantially intact.
Yep.
Or it's substantial
with regard to
conformance with its present
vegetation.
Yeah, with regard to vegetation.
Substantially in its existing condition with regards to vegetation. Is that what I heard?
Yeah.
Okay. Okay. Mr. Chair, any other
Manny, and then just building height not to exceed
Yes.
16 feet.
16 feet.
Mm-hmm.
And
How
then
are we describing that building?
I think it's a temporary structure myself, but I don't know.
Temporary membrane structure.
Okay.
They're going to see that as temporary, definitely.
Okay.
I think they need to, otherwise it's going to have sprinklers in it.
We forgot no customers on the property. No customers doing any work on the property. We agreed to that with the neighbors.
Yeah, yep. I think that's covered.
And then I guess the only other thing I would like to add is that the use remains in compliance with wellhead restriction where water supply is becoming such an issue, I just think we need to make sure that it's in compliance.
No
I don't
objection.
know the regulation, but
No objection to that.
All right, those are my circuitous conditions.
Anna, how do you feel about that? Did we give you what you needed?
I think I got it.
Okay.
Thanks, Anna.
And
So-
I'm taking notes. I'm not sure they'll be helpful, but I'll try
Okay.
if you have questions.
Were you going to say something there?
Nope.
You got them all? You good? All right, so we'll do a roll call vote on the conditions for the special permit in appeal number 2023-029. Herb Bodensee,
I am in favor.
Mark Hansen,
I'm in favor.
Aaron Webb,
I'm in favor.
Manny Alves,
In favor.
and I'm also in favor. So, Attorney Lawler, Mr. Crosby, you have your special permit with lots of conditions. Good luck at site plan review. Hopefully, we don't see you back here.
I hope not. I want to say this, honestly, guys, and thanks so much. I know you guys made a lot of, and I think the correct calls, but difficult calls on this from normal procedure. And it is much, much appreciated by my client and myself. Thank you very much.
Well, thank you for working with your abutters to come with positive feelings about it.
And thank you to the abutters, because that really is always the key. Having good neighbors. Thank you. And he does have some good neighbors. Thank you so much.
Thank you.
Good luck.
All right, back to the thing. Does anybody go to the bathroom or anything? We good?
Good.
Let's see. No, Jesus, where am I here? Next item. We've done that. Appeal number 2023-030. Dennis and Lisa Van Oosenen have applied for a special permit pursuant to section 240-92B. Non-conforming buildings or structures used as single and two-family residences. The applicants seek to construct an addition, bring the gross floor area to 4,259 square feet, where the existing gross floor area is 2,242 square feet. The subject property is located at 45 Vineyard Road, Katuitt, Mass, as shown on Assessor's Map 016 as parcel 001. It's located in the Residence FRF zoning district. Sitting on this will be our regular members, Herb Bodensee, Mark Hansen, Aaron Webb, and Larry Hurwitz, and myself.
Mr. Chairman, if I may, real quick, could I defer to Manny for this
For
hearing
sure.
if he's willing?
Yep. Manny, you're good?
Yep.
For sure. All right, so I'm Manny Alves.
Appreciate that. Thank you.
All right. Attorney Schultz, is this one yours?
It is. Good evening, Chair Dewey and members of the board. Attorney Michael Schultz on behalf of the applicants, Dennis and Lisa Van Oosenen. With me this evening are the architect, Tim Luff, as well as the applicants, Dennis. I did see him here on the screen. As noted in the introduction, the applicants are the owners of 45 Vineyard Road in Katuitt, and they've applied for a special permit to allow the construction of an addition to an existing single-family dwelling. 45 Vineyard Road is shown on Town of Barnstable Assessor's Map 016 as parcel 001 and is comprised of approximately 1.51 acres in the RF zoning district, the AP district, and the Resource Protection Overlay District. The property is improved with a single-family dwelling that was constructed by Bogate Architects on the 1.51 acre lot between June and September of 1970. It was a pretty neat finding to be able to see that. I did attach it to my memo to the board. There were notes of the architect that the owners had that we attached to it, reflecting the construction of the dwelling. Attached to my letter as well, I would submit to the board that the dwelling is consistent with the rest of the neighborhood in terms of size and setbacks on the lot. I did append a GIS map which reflects the lot and the abutting lots in relation to it. In 1970, the property was located in a residential D zoning district, which at that time required 20,000 square feet of area, 125 feet of width, 30 feet of a front yard setback, 15 feet to the side and the rear, but there was no height or story limitation at that time. I did attend for the board's record as Exhibit 3 and 4 to my letter, the 1960 zoning bylaw, as well as the map reflecting the provisions and the location of the property. When constructed in 1970, the dwelling was conforming in all respects. With respect to the proposed addition to the existing dwelling, it's reflected on the All Cape Septic LLC site plan and elevations prepared by Architect Associates and Tim Luff, dated June 7th of 2013. The applicant's proposal meets the requirement of section 240-92A1, but is unable to meet under the present zoning 240-92A2 based on the story requirement for the issuance of a building permit, which requires the relief from this board under section 240-92B. Based on the facts that follow, the applicants would respectfully submit that this appeal does fulfill the spirit and intent of the ordinance and satisfies the requirements for the issuance of a special permit. First and foremost, the application does fall within a category specifically accepted in the ordinance for the grant of a special permit. That is section 240-92B, where if you're unable to meet the requirements of section A, this does afford the relief in the form of a special permit. That the proposed alteration or expansion of a pre-existing non-conforming building meets that section. The findings required under 240-92B by this board is that the proposed alteration or expansion would not be substantially more detrimental to the neighborhood than the existing structure. I would submit respectfully to the board that based on the site plan by All Cape Septic Design and the Architect Associates plan dated June 7th, that the proposed front yard setback is greater than 30 feet, and that we meet all of the requirements of the RF district. The proposed addition by Architects Associates simply extends the pre-existing non-conforming building in its original 3-story design, where if it were designed at 2 or less than that stories, it would be less appealing from an architectural standpoint. Finally, I would submit that to the board that the applicants have received the support of their neighbors. I did append 2 letters, one from 21 Vineyard Road and one from 25 Vineyard Road. I did identify on the plan attached to my letter where those are located in reference to the house, and that they were in support of the proposed plans and that it would not be substantially more detrimental to the neighborhood. Based on the foregoing, I'd respectfully request that the board grant that relief in the form of a special permit and would turn it over to members of the board now for any questions that you might have. And Tim Luff is available as well. Thank you.
Thank you, Attorney Schultz. Any members of the board have questions for the applicant? The biggest question before us basically is this more detrimental to the neighborhood or not? We have the power to approve it if we determine it's not. Go ahead.
I have one question, and I think you just said it, Attorney Schultz, so forgive me if you did. So the proposed addition would still stay within the setback requirements, correct?
It would, yes.
Yeah.
It's really just the 2-story nature.
Yep.
The height is the issue, correct?
Yep.
It's only the story. From a height standpoint, we remain grade to top of plate. We're under 30 feet.
Yeah. Any other board members? Questions? All right, so let's open for public comment. We did receive 2 letters in support. I've got a letter dated September 12, 2023 from Pini and Margalit Suissa in support. And I've got a letter from Mark Capallo, also in support of the project. Anyone here to speak to this item? All right, seeing none, I'll make a motion to close public comment. I need a second.
Second.
Roll call vote to close public comment. Herb Bodenseek.
I'm in favor.
Mark Hansen.
I'm in favor.
Larry Hurwitz.
In favor.
Manny Alves.
In favor.
And I'm also in favor. So public comments closed. It brings it back to the board for deliberation, or if someone wants to make findings. I personally think it's pretty straightforward. It makes sense. I'm not really sure why the bylaw is written that way, but it is.
Just a quick question. Is it a contemporary? I'm looking at the plans.
It is, and I'll defer to Tim. I see him nodding his head, but yes, modern contemporary structure.
Okay. And so really, if anybody had seen this, if they had issue, we would assume they would have come forward. I'm assuming it isn't exactly like what's around the area, but, can't imagine if it was that much of a concern to the neighbors. They were all notified. So I'm assuming there would have been public comment if there was question about the actual design itself.
Yeah, that's correct. And it's been there since 1970 and was designed by an architect in New York City at the time.
Sure. Makes sense. Okay. Thank you.
All right. Anyone else? Does someone want to make findings?
I'll do.
Go ahead, Manny. Thank you.
Okay, this is on special permit application number 2023-030. Dennis and Lisa Van Usanen, forgive me if I'm mispronouncing the name, have applied for a special permit pursuant to section 240-92B, non-conforming buildings or structures used as a single and two-family residences. The applicants seek to construct an addition, bring in the gross floor area to 4,259 square feet, where the existing gross floor area is 2,246 square feet. I'm tired. Subject property is located at 45 Vineyard Road in Katuitt, as shown on Assessor's Map 016 as parcel 001. It is located in the Residence FRF zoning district. For special permits, the board is required to make general findings pursuant to section 240-125C. The board should review the evidence presented by the applicant, staff, and members of the public, and after weighing such evidence is encouraged to articulate if and how the evidence contributes to each of the following required findings. Finding number 1. The application falls within the category specifically accepted in the ordinance for a grant of a special permit. As we've heard and as shown in section 240-92B, the board has the authority to allow for the alteration of a non-conforming dwelling on non-conforming lot pursuant to a special permit. Finding number 2, site plan review is not required for single-family residential dwellings. That is, I find that is accurate. Finding number 3, after an evaluation of the evidence presented, the proposal fulfills the spirit and intent of the zoning ordinance and would not represent a substantial detriment to the public good or the neighborhood affected. We have testimony and evidence from neighbors who are in favor of the proposal, and while the project is being extended, its encroachment is not increasing. It will stay within the zoning setback requirements as has been represented to us. So I find it would not represent a substantial detriment to the public good or the neighborhood affected. Similarly, the alteration would not be substantially more detrimental to the neighborhood and to the existing dwelling. These kind of run into each other. The applicant intends to maintain the current height of the building, which, although not consistent with what they would be able to do as of right, if it was just a one-story structure, that does not substantially become more detrimental to the neighborhood, as evidenced by the support of the neighbors, and the fact that the structure will still remain within zoning setbacks. Those are my findings.
Thank you, Manny. Do I have a second?
I'll second that.
Herb seconds. Roll call vote on approving the findings. Herb Bodensee.
In favor.
Mark Hansen.
In favor.
Larry Hurwitz.
In favor.
Manny Alves.
In favor.
And I also in favor. Do you have some suggested conditions?
Yeah, Attorney Schultz, the suggested conditions in the staff report dated October 12, numbered 1 through 6. Those acceptable to you and your client?
I have reviewed them. I would have 2 minor suggestions for you to review, if you don't mind. Just on condition number 2, that we add to the end of that sentence that and plans prepared by Architect Associates dated June 7th, 2023, so that it's being built in conformance with the site plan and the plans provided by Architect Associates. And then on number 3, just a small little comment. We are dealing with a larger lot, so that my proposed condition would read, the proposed redevelopment shall represent full build out for the principal dwelling. Further expansion of the principal dwelling is prohibited without further approval from the board. So where I would, hesitate and just suggest to the board that if they were building a pool or something along those lines, that it wouldn't need to come back to the board.
How big a
I'm
lot?
fine with that.
I'm sorry, Mark, I didn't.
What is the size of the lot currently?
1.51 acres.
Oh, okay.
So are those the conditions, Manny?
Yep.
All right. So
As revised by Attorney Schultz.
yes. So we'll take a roll call vote on the conditions as revised. Herb Bodenseek,
In favor?
Mark Hansen,
In favor.
Larry Hurwitz,
In favor.
Manny Alves,
In favor.
and I also am in favor. So Attorney Schultz, you have your special permit.
Thank you all very much and have a nice evening.
Thank you.
Not over yet.
To our last items of the night, appeal number 2023-031, Randall Green and Richard Lee Jr., trustees of the Allen and Sherry Green Revocable Trust, have petitioned for a variance pursuant to section 240-7C and D and 240-11 bulk regulations, minimum lot acreage and shape factor, and 240-91 undersized lots. The petitioners seek a land swap to change the configuration of the 2 existing lots without changing the acreage of each resulting lot. Subject property is located at 99 Center Street, Centerville, Mass, as shown on Assessor's Map 251 as parcel 016. It's located in the Residence D1 RD1 zoning district. In appeal number 2023-032, Randall Green has petitioned for a variance pursuant to section 247C and D and 240-11 bulk regulations, minimum lot acreage and shape factor, and 240-91 undersized lots. The petitioner seeks a land swap to change the configuration of the 2 existing lots without changing the acreage of each resulting lot. The subject property is located at 101 Center Street, Centerville, Mass, as shown on Assessor's Map 251 as parcel 220. It's located in the Residence D1 RD1 zoning district. So sitting on these 2 items will be our regular members, Herb Bodenseek, Mark Hansen. Aaron, do you want to come back for this one? Doesn't look like it. Larry Hurwitz, Manny Alves, and myself. Attorney Johnson, over to you.
Good evening, Mr. Chairman and members of the board. I thank you for your patience this evening. In light of the hour, I'll try to make this as short as I can. Anna, is there any way you could put up my site plan on the screen? The one that has the yellow and blue highlights? Anyway, while she's doing that, I'll just go through the parameters here. We have 2 existing dwellings. The first one, the house on the lake, as it were, was constructed or reconstructed in 2000, and the house that Randy Green himself owns, which would be 101 Center Lane, was constructed in 2013 and 14. I have just one issue with the staff notes. The staff notes was reading the field card in a section that said that 101 Center Lane only had 2 bedrooms. If you look further into the field card, you'll see that it had a permit for, and in fact actually has 3 bedrooms. So there's a 3-bedroom home on 101 Center Lane and a 4-bedroom home on 99 Center Lane. Alan Green and his wife Sherry lived for many years in this house. He was a prominent lawyer in the town. Please don't hold that against us. And he and Sherry raised their mixed family at this house for many years. They have both since passed away. The 8 children they have between them are the beneficiaries of the trust that owns that house, and the trust has decided to sell the lakefront house. The existing property lines that you can see are in yellow for 99 Center Lane show Alan Green and Sherry Green's house. But Alan and Sherry Green's house has an exclusive easement for a driveway and to use the existing detached garage. If we were to redraw the property lines, which would be the blue line, that would make the use of an easement for the garage and the driveway not necessary, and it would be an easier item to sell visually and as a practical matter to potential buyers. We're suggesting to you that that there is, in fact, one unique thing under Factor 1 of 40A Section 10, and that is a uniqueness as to a structure. This existing garage was at one time a cottage on the lake, and it was converted to a garage at the time in which Randy and Patricia Green built their house in 2013. I have Randy here. He's contacted the neighbors, and all the neighbors that he spoke to spoke in favor of it. We are not increasing any use here whatsoever. The number of bedrooms is going to remain constant. As you can see, we're close to the lake. Alan Green's house is all within, and the new property line would actually keep it within 100 feet of the wetland. One of the conditions that was suggested in the staff report was that we would consider this a further build, a final build out or a full build out. We would ask you not to enter that condition. Specifically, there's nothing before you now, but it is Randy's hope, who lives at 101 Center Lane, to eventually build an accessory use apartment for himself. He presently lives in the home with, he's a widower. He lives in the home with his daughter, son-in-law, and their children. And at some point, he is considering doing the accessory use. He understands that, frankly, he'll have to give up one of the 3 bedrooms in the main house to be able to do that, but might want some independence in his future, especially as his grandchildren become teenagers. I'm sure you can all understand that desire if you have any teenagers in your lives. This is really no intensification of use. It's not substantially more detrimental to the neighborhood. It's really not going to change the actual use of the 2 properties in all practicality whatsoever. I would frankly entertain questions at this point, if anybody has any questions as to what we're trying to accomplish here.
So, Attorney Johnson, Mark Hanson. So, just for clarification, currently there's an easement as they come off center lane. They get to use that garage. And
yes.
Any use of that garage currently is under easement or no?
It's under an easement. In the package I submitted, you'll see one of the documents in the title histories at book 28, 334, page 42. In the title history to Randy's house, you'll see that there is the grant of the easement from Randy and Patricia in favor of Alan and Sherry, Alan being Randy's father, Sherry being Randy's stepmother. There's a nice picture attached to that easement in the final page of that document, page 47, that shows the area in which the easement exists for this driveway and for the garage. And this lot swap would take essentially the easement away and make that use that has for practical purposes been in existence since 2014 and put it all onto one lot. We're trying to make this property on the lake more attractive to buyers, more easily to understand. The members of the board who deal in real estate, I think, will agree that sometimes trying to explain easements and exclusive easements to people creates issues and questions. And there's always questions about, well, who owns, if you own the underlying property, who has to insure it? And we're taking away those issues with regard to 99 Center Lane by adding this acreage to 99 Center Lane, but giving up acreage in favor of Randy Green's property. The swap is exactly of the same size parcels. The resulting lots are to the square foot, identical to what exists now. The only true difference is that Randy Green is giving up more lake frontage than he's getting in this swap, but that's his choice, and he's trying to do that for the benefit of all 8 of the beneficiaries of the main house, the lake house, I would call it. And we would hope that you would consider this as a fair and common sense solution to a problem that creates, I would say, not a financial hardship as much as a hardship otherwise. We would obviously like to get more money for the property and feel we could get more money for the property if we make it all contiguous, the garage and the driveway to the property. And we would strongly ask you to consider that.
And just one last question. So does would the resulting land swap, would there be any sort of a permanent physical structure or tree line or anything like that be going up in, along that lot line? Or is the petitioner or the other gentleman, is he aware that there could be something delineating that property at some point? Is he okay with that?
Well, Randy is going to still keep the house, and if they put anything along that new blue property line, it would block his view. I think the topography, if I'm not mistaken, Randy, doesn't it slope down towards the lake? It slopes down towards the lake.
Okay.
So with the height restrictions of fences, it wouldn't really block his view. And I don't believe that a buyer of the house on the lake, and I don't mean to kill any sales here, but would have a difficult time adding to the lake house because it's within the 100-foot buffer zone of the Conservation Commission. There's a stone wall shown on the plan there that's almost exactly 100 feet from the wetlands. And I asked Randy, and his brother Tim is here, whether as a practical matter anybody could even add a garage there, and they said it would be very, very difficult. But we don't want to tie up this property by your suggested condition number 3, but we're perfectly happy with the other 3 conditions that have been suggested by the staff report.
Attorney Johnson.
Yeah, go ahead.
I'm sorry, go ahead.
Go ahead, Manny.
I guess a question about specifics. Is the reconfiguration of the lots going to cause, let's focus on 199, to fall within setback restrictions?
So we meet all setback restrictions with the old line and the new line, except for the setback of the existing garage, which is staying where it is. And that was a pre-existing structure from 1958 that sat that close to the lot line. That's the only violation of any setback requirement at all. We're not asking for setback relief. The only relief we're really asking is for the line. And honestly, there's an argument that maybe we might need relief on the shape factor, but I'm not sure the old lots met the shape factor either.
So as to the garage, it's just the ownership that's changing.
Yes, so right now, the ownership of that garage and or most of the driveway is technically owned by Randy Green, but it's subject to an exclusive use easement in favor of the lake house. So as a practical matter, Randy owns it, but he doesn't get to use it. And he doesn't get, he owns the dirt underneath it and the dirt underneath the driveway. But this reconfiguration, he won't own that, so it won't be his problem.
Thank you.
Split it right off.
For liability and insurance and that sort of thing, and just neighborly relations, I think that this new configuration will help the future because, not to disparage any of the Greens or the Lee family, but I don't think any one of the 8 of them could buy out their 7 siblings with what this property on the lake is worth. Or if they could, they don't want to.
Any other board members have questions? Is the I can't remember which number it is. So these are both single family. I mean, I
Yes.
see reference to an apartment in the larger home. There's
no apartment in the larger apartments anywhere.
Okay.
At one time, the garage was a cottage. But when Randy got to build his house in 2013, they took the 1-bedroom cottage and converted it to a garage.
Okay.
And again, there are a total of 7 bedrooms between all the properties, and we certainly would, instead of number 3 on the suggested conditions, you could certainly condition this grant that there never be more than 7 bedrooms between the 2 properties.
Okay. I mean, you're going to get sewer there soon, I think.
Well, we were just told it's going into phase 2 now.
Phase 2.
But the good news is the lake house passed the septic test the other day.
Okay. Good. Any other board members with questions for the applicants? I can't see you all, so speak up.
Nope.
I have one question. You mentioned a future ADU. Would that have to come before us again, or would it go through the building department? And if you wanted to do something other than the 900 square feet, then it would fall back to the ZBA?
Yes, if we wanted to build something bigger than the 900 square feet, we would be back before you. But I've suggested to Randy to get rid of his old sports gear and get ready to live in 900 square feet.
Good.
My wife would like me to get rid of my things, but she hasn't pushed me out yet.
Does someone, let's see, we have to open public comment. I'll open public comment. Anna, did we receive anything regarding this? I don't think so.
Let me unshare. No, we didn't.
Randy is here and he can tell you what affirmative text messages and emails he got from the neighbors, if you'd like to hear that from Randy.
Sure.
Randy, would you explain to the board who you heard from?
I heard from the majority of the neighbors back that none of them have a problem with it. I heard from the gentleman that's in charge of our association in the neighborhood, and he said that he presented it to the board and none of them had a problem with it either. So basically, anybody I heard back from was fine with it.
Okay.
And obviously, you can't see it on the plan, but to the other side of the lake house is Randy's brother, Tim, who is also here this evening, and certainly he's in favor of it. He's one of the 8 beneficiaries of the trust that would like to sell.
Okay. So I guess I'll make a motion to close public comment.
Second.
You have a second?
Second, Mark Hansen.
All right, so roll call vote to close public comment. Herb Bodenseek.
In favor.
Mark Hansen.
In favor.
Larry Hurwitz.
In favor.
Manny Alves.
In favor.
And I also in favor. So that closes public comment. It brings us back to us to deliberate. I guess I just want to have a discussion or pitch it back to Attorney Johnson. Just, are we leaning on soil conditions, shape, topography?
I would lean on structure.
Okay.
So you have a pre-existing non-conforming structure that's part of an easement that's attached to a property that doesn't own it. And the uniqueness of that situation with regard to that structure makes this variance make sense if we take away the easement and put it into ownership.
And the structures were built in what year? They were built before zoning?
So before zoning in this area, the cottage is shown on a plan that's in my package dated 1958. Zoning went into effect in Barnstable for residential purposes in 1954, but there weren't any setback requirements at that time. It was just residential versus commercial, that sort of thing.
Okay. Does anyone have any questions or want to make findings or thoughts? Just remember, it's a variance. We need to pass the three-prong test.
Does anyone, you understand my position on the other two prongs, correct? The hardship is financial and otherwise, the otherwise being, it makes more sense just conceptually to have the lot homogeneous. And in terms of not substantially more detrimental to the neighborhood, we're not increasing anything whatsoever at this time. The number of bedrooms is going to stay consistent. The driveways are going to stay consistent where they have been since 2014. Nothing else is changing.
Someone want to make findings? Mark, you're usually good at variances.
Yeah, I'm looking at, so are we, just so I understand, are we reading both? Or are we just taking the one here, 2023?
We need to do both because we need to give it to the benefit of each lot.
Oh, I see. Okay. But it's the same. It's essentially the same.
The same thing. It's just one lot's getting it and the other lot's also getting it, but like reverse of the plan.
Okay. I'll give it a go.
I mean, Attorney Johnson, do you feel comfortable if we read them both into the record and grant them simultaneously?
I'd be extremely happy so long as the vote goes in the right direction.
Because Mark, I think we're going to have the same justification on both of them.
We are. Anna, is that okay though that we do that?
Yeah, as long as they're the same findings and for each, sure.
So read both in and then, and then findings for both?
Yep.
Okay, so it's just because I don't have the other one up. Is it 2023-031 and what's the other one? 2023
31 and 32.
032. Okay. With regard to variance number 2023-031, Green and Lee trustees, Randall Green and Richard Lee Jr., trustees of the Allen and Sherry Green Revocable Trust, petition for a variance pursuant to section 240-7C and D and 240-11 bulk regulations, minimum lot acreage and shape factor, and 240-91 undersized lots. The petitioners seek a land swap to change the configuration of the two existing lots without changing the acreage of each resulting lot. The subject property is located at 99 Center Lane, Centerville, Mass. I'll just read the one here. According to the application, lots are pre-existing non-conforming with regard to current acreage requirements. The detached garage is pre-existing non-conforming as to the front and side yard setbacks since 1958 as proposed. The properties contain two dwellings as well as one detached garage. Present zoning would require each lot to contain 2 acres. The proposed land swap only changes the configuration of the two existing lots involving without changing the acreage of each resulting lot. 99 Center Lane already enjoys an exclusive easement for the use of the garage, which garage after the land swap would become part of the property addressed as 99 Center Lane. 101 Center Lane will lose the lake frontage near the garage, but would receive in exchange lake frontage on the opposite side of the dwelling at 99 Center Lane. There is no new construction as part of this petition. And with regard to, sorry, I'm pulling it up. Appeal number 2023-032, Green. Okay. Sorry. Moved a little slower there. Randall Green is petition for a variance pursuant to section 240-7 C and D and 240-11 bulk regulations, minimum lot acreage and shape factor, and 240-91 undersized lots. Petitioner seeks a land swap to change the configuration of the two existing lots without changing the acreage of each resulting lot. The subject property is located at 101 Center Lane, Centerville, Mass, as shown on Assessor's Map 251 as parcel 220, as it is located in the Residence D1 RD1 zoning district. Variance findings for both 2023-031 and 2023-032 are as follows. Owing to, number one, owing to circumstances related to soil conditions, shape, or topography of such land or structures, and especially affecting such land or structures, but not affecting generally the zoning district in which it is located, I find that the garage structure currently located in Mr. Green's parcel, which was once a cottage. It is now presents an easement. It poses an issue with regard to a clean title as far as the sale of the lakefront property, and the structure has a significant impact on the value of that property. Number two, a literal enforcement of the provisions of the zoning ordinance would involve substantial hardship, financial or otherwise, to the petitioner. I find that not making this land swap would make the lakefront property, which is the desires to sell, less attractive to potential home buyers, and that this will clear up what is currently a liability, a potential liability for the current owner. Number three, desirable relief may be granted without substantial detriment to the public good and without nullifying or substantially derogating from the intent or purpose of the zoning ordinance. I find that the land swap does not change the non-conforming or conforming nature of the properties as they exist. The land swap is equal in either direction, and there is no new construction related to either of these petitions. Those are my variance findings.
All right. Thank you, Mark. I need a second to approve the variances as read. Herb seconds. Roll call vote. Herb Bodenseek.
In favor.
Mark Hansen.
In favor.
Larry Hurwitz.
In favor.
Manny House.
In favor.
And I am also in favor. Are we conditioning these the same? Attorney Johnson, are you asking for the same modification for both parcels?
You're muted, sir. Attorney Johnson.
The suggested variance conditions are fine, except that I would ask that number 3 be modified to only limit the number of bedrooms on each parcel. I would not want to suggest that this is a full build out of either lot. Somebody might want to do something else on the lakefront property. And as of right, the way the properties exist now, a full build out would technically mean that Randy couldn't get the accessory use dwelling, even if it was under 900 feet, without coming before the board. So I would ask that that not be a condition, that we just modify number 3. Numbers 1, 2, 4, and 5 are fine.
So so specifically for 032, you're asking that number 3 be modified to only represent that the bedrooms remain the same?
The lakefront house be limited to 4 bedrooms, and the property at 101 Center Lane be limited to 3 bedrooms.
I don't see how that helps your position.
I think that's fine.
Is it okay?
We're willing to swap in the existing house.
Oh,
So
you want to swap one out? Okay.
Yeah, the staff report is wrong. It says that 101 only has 2 bedrooms, but it really has 3. And the building permit, if you look later in the staff card, you field card, you can see it has 3. And we're willing to swap out one of the existing bedrooms for an ACU bedroom. The size of the lot only supports 3 bedrooms anyway until the sewer comes in. And like I said, we got word the other day that we're looking at phase 2 now.
Okay, so you're proposing that number 3 read that there'll be no further expansion on the lake house beyond 4 bedrooms, and of the abutting property at 3 bedrooms, correct?
Correct.
So the lake house is is it 101 and 99?
99.
Respectively?
99 is the lake house.
99 is the lake house. Okay, so that the bedroom count at 99 Center Lane remain at 4 bedrooms, and that the bedroom count at 101 Center Lane remain at 3.
Without further relief from the...
Without further relief from this board. Is that fine?
Yes.
That's fine.
Okay.
All right. So did you reference the conditions? You just reference them.
Number 1 through 5 dated on, are both staff reports the same date?
Yes, I think so. Well, October 12th and
October 12th,
yeah.
2023.
All right, and roll call vote to approve the conditions for 2023-031 and 32. Herb Bosensee.
I am in favor.
Mark Hanson.
I'm in favor.
Larry Hurwitz.
In favor.
Manny Alves.
In favor of the conditions as revised.
And I am also in favor. So Attorney Johnson, you have your variance.
Thank you very much, ladies and gentlemen. We're on to the planning board now.
Thank you. Good luck.
Thank you. Thank you.
Thank you.
Good luck.
All right. Correspondence, we have none. Matters not reasonably anticipated. I don't think we have anything. Does anyone have anything discussion-wise?
Negative.
Councilor Clark, did you have anything to add? You're still there with us. Upcoming meetings November 8th. So that's in person. Or that's Zoom. And
Zoom.
And December 6th is also Zoom. Oh, sorry. And then our discussion about our 2024 proposed schedule. I know there was some discussion, I think Aaron's gone, regarding in-person versus not in-person. I don't know what people's thoughts are. I thought it was a pretty equitable way where we don't have a hybrid option, that we do one in-person, one Zoom, and if we have controversial issues that we have a lot of public outreach and public comment, we can carry them over to 2 meetings so that people from the public can come to us both on Zoom and in person, because I hear from both sides. I hear people that say they can't get to town hall for a meeting and that's crazy, and they want to be home and be able to jump on Zoom. And then I hear from other people that they hate the technology and they hate talking on their computer, so they'd rather come speak to us in person. That was my rationale behind that, but I'm open to discussion on it.
I'm still open to the idea of how we had been doing it with one on, one off.
Manny, Larry? Herb?
I always prefer in person, but I understand the need to do the hybrid situation.
Yeah. I really enjoy in person.
Yeah, you certainly get a better read. And I think for more complicated issues, being in person is definitely it's preferable. But I think there's still a significant portion of the population that is not here during the winter season and just doesn't allow them an opportunity to. They're not going to fly home in order to sit on something that maybe abuts them or affects them.
I agree. I think having given people have tasted that ease of participating, I don't think you can put the cat back in the bag.
No.
So I think this is a good compromise.
Yeah.
Yep.
Okay. So, and and then we don't really have the power to change the dates of the schedule, really, do we? I mean, that's sort of set by our guidelines that they are what they are in the month.
Right. The 2nd and 4th Wednesdays of the month.
The other nice thing, honestly, through the winter months is that we are not weather dependent when we're on Zoom. So we don't get meetings that are canceled or shut down or anything like that. Assuming internet is up, we're functioning.
Yep. Okay. Any other comments or communications discussion?
Not on this subject, but I guess I've been thinking about this, and maybe I appreciate the lateness of the hour. We can take it up some other time. But as a Board of Appeals, I guess I was looking to see a negative finding by the enforcement officer before something comes to this board. I guess I've been thinking about it. I worry that we may approve something that actually doesn't address all of the nonconformances. Am I missing something? I'm looking at you, Anna. Do we actually get a denial letter from? In other words, people are appealing a decision before they come to this board, and I don't.
They're appealing a bylaw, really, I think. But if they've been to informal or formal site plan review, the building department's reviewed it and determined it unapprovable.
No, I'm thinking more for single families where we don't do a site review, right?
Yeah.
Is that? Do we get an order? Anyway, it just. Yeah. You know why I'm doing this is I'm and I'll move permanently and I was packing stuff, and I used to do this at the town of Milton, and it was one of the key things in the findings that the petitioner is appealing the order of the enforcement officer dated XYZ denying the particular proposal, and it's coming on appeal.
We do get that.
You think they should file a full building permit and then get denied the building permit and come to us rather than, I think right now, a lot of the times the engineer is saying, hey, this isn't going to be by right. You're going to need an appeal. You're going to need to appeal this. And then they tell them to call a lawyer, and they call a lawyer, and the lawyer agrees and says, yes, you're going to have to go to the zoning board to get a determination here.
Right. You're sort of relying on the applicant and their parties to do it. Okay.
No, usually in the case of like a single family house being denied a permit for whatever reason, a permit for whatever purpose, usually we'll have a copy of the building commissioner's letter and rationale for making the decision. But I think that's what you're asking, right?
Yeah.
Yeah. So we will have paper, we'll have backup of, yes.
All right. Okay. Sorry.
I've got more of an issue where we end up going backwards, kind of similar to what we may have just seen, possibly where we're guessing. It's like a backwards thing where, say, formal site plan hasn't happened, and we're making decisions. I mean, it could be a complete waste of time based on what the requirements are. It could be something as simple as, the ability for a fire truck to turn around or something like that. And I mean, we can save a lot of the time, with things like that. I don't know. With things that seem obvious, I'd like to have more weigh in sometimes, or we should, I think we can be more forward with continuing things sometimes until we get, more of either a written or a true verbal response from some of the, whether it be DPW or fire or whatever it ends up being. I don't think we use that enough. I mean, I understand sometimes the way things go, but I can think of a couple of instances in the last little while where we've said, really, they're not asking you about that, or, because we're just going on the petitioner's word a lot of times as to, I mean, granted, they still have to go through site plan, things like that, but I think a lot of times there's information where we could use the input of the town or what is their actual feeling about things, whereby whether it's a zoning issue or something like that, where we could maybe push it. I know we don't like to, but I think we should do it more often, to get clarification on some of these details. Anyway.
Yeah, I mean, I think it's something to keep it. I mean, again, it would take an act of council, I think, to change that, like, single family had to go to a site plan review process. And I don't know if that's necessary with the volume of things that come along right now, but if we were.
Yeah, I'm more speaking maybe not so much the single family stuff, but more these, type of business activities or multifamily stuff or whatever.
And it is a requirement for anything over a 2-family to go to site plan review. So
right.
I don't know if the requirement says they have to go before they come to us. I think it's just a requirement of the approval process.
It would just be
I don't even actually know on that decision we made. It says, I think in the bylaw, it says site plan review is required. So I'm not sure how that's going to play out. But.
Okay.
All right. Does someone want to make a motion to adjourn?
Motion to adjourn.
And a second?
Second.
Roll call vote. Manny Alves.
In favor.
Mark Hanson. Herb Bodens. Mark Hanson.
In favor.
Herb Bodensee.
In favor.
Larry Hurwitz.
In favor.
And I am also in favor. Thank you guys. Good to